Item number 648.
After that, what is the other thing that the other thing that matter has to pending and it takes for selection after the derivative to the constable artist and it takes for the and then philosophy. I know that there is a number of matters with philosophy and some time either tomorrow or day after, otherwise I can decide on the opportunity of sitting and that will I have to stop at front way that is my requirement. I have given notice to the other side also. Mr. Margaret from the other they have their all activities are completely to take hardly 10 minutes. I will not take more than that. Only one statement I have person inspection I cannot come to the phone. But either tomorrow day after Monday can fix up the time. I will take only 10 minutes time.
When is the examination scheduled?
The examination schedule that 15th of October they have said, but any moment they can do it. First couple of time back, that is the instruction that the date will be announced in the course of any date in the next day. That is the problem. Otherwise, I will not have trouble.
This week it may not be possible, Mr. Rai, not this week. Maybe in the next week I'll be taking up some urgent hearing matters. You please write the grounds of urgency in your mentioning slip and give. I'll check up in my chamber and I'll arrange because there are some matters which I will list for hearing in the next week.
I have given the notice, and I think this notice I will find about the mentioning.
Please, 648 बोल 648 mark करो लेकिन.
Your Lordship,
Yes.
Lordship, I crave leave to mention a matter. It's an income tax matter, Your Lordship, wherein my lord, the department is making adjustments from my refunds for assessment years, wherein Your Lordship more than 20% has long been adjusted. Matter is pending in appeal. It's a covered issue, Your Lordship, and despite the pendency of the writ petition, Your Lordship, the department has issued fresh notices for adjustments. We objected.
It's there in the list or not?
It is not running in the list, Your Lordship.
In the urgent. Please wait. Listen.
My lord, may I, my lords, leave to mention an urgent matter, my lord, from the determination of Honorable Justice Hiranmay Bhattacharya, my lord. My lord, in this matter, the petition number 1 and the respondent authorities and these has been executed, and the petition number 1 is allowed to sublease a portion thereof to any of his associate companies. My lord, the respondent authorities have agreed in principle. The formalities are only to be done, my lord. They're sitting over the representation. My lord, it's a very short point. I'm mentioning it upon notice, my lord. And it is subject to my lord. Yes, my lord, group 1.
Group 1 আমরা বললাম না একদিন আমরা রিভিউ করব তিনটে ম্যাটার হয়ে গেলে একবার দিয়ে দিই গ্রুপ 1 আজকে নিয়ে আসবেন
But may I have your lordship kind leave to mention a matter
going this side I'll come
from the list and determination of Honorable Justice Hiranmay Bhattacharya. I had mentioned the matter on Monday and lordship was pleased to allow it.
yes
The restaurant matter, my lord, 30-40 families
on which I'll be taking up group 1 matters in this week only.
My lord, this is extremely urgent, lordship. 30-40
something is going to happen.
My lord, 30-40 families, their livelihood have stopped because the restaurant is shut down. The respondent authorities are not giving me permission, insisting on the signature of the co-lessee, my lord. My livelihood at stake, my lord.
আচ্ছা কথা হলো
Notice it will appear next week, not this week.
My lord,
This week not possible.
fix a date, my lord.
That I'll do, but don't expect it this week only. Maybe because
Well,
I have
an
taken the
extremely
application with an urgency, my lord, may be heard the next week, any day next week. My lord, the custodian of enemy property has classified my property.
file it, it will be taken up next week.
Time to time.
Please file it and then mention, because
Like
you're,
the only
please
difficult-
file it and then mention. I think I've made myself clear, sir. Don't go on arguing on this. Please file it and mention.
Well, an
Yes.
extremely urgent matter of the determination of Justice Hiranmoy Bhattacharya. Well, in view of the urgency, my lord, the matter was even the additional district magistrate was directed to be personally present virtually. But my lord, on that day there was change of determination, and my lord, the learned advocate on record was ill. That's why the matter could not be taken up before Justice Bhattacharya. The Fishermen's Society are being completely resisted from conducting pisciculture.
Give it. It won't appear this week.
My lord,
as-
next
as
any
indicated.
deep
Lordship, I would kindly to mention this matter from the determination of Justice Hiranmoy Bhattacharya. This for the extension of interim module. Lordship,
When
I
is
have
it going to expire?
filed. It is expired. I have filed the application for extension.
If
of
it is
interim
expired,
module.
please wait. Yes.
This matter for entry order is going to start.
Yes.
Kindly, Lordship, any day, Your Lordship.
If it has expired, no.
One matter for non-proceedings.
Yes, yes, please give it.
I have your lordship kindly.
220. Yes.
This is the GST matter, my lord.
maybe
After filing the leave petition, the department is initiated the recovery proceeding. In spite of my deposit of 10%.
Please give this slip urgently. দিয়ে দেবেন এটা যে কোনো দিন। Please keep a watch on the list.
What happened on a possible was order was passed in my favor. In spite of that, my lord, they have not issued the notice. Since the order of 10th in my favor, I could not file any appeal or other second court of order to higher appeal. But these are determinants of my lord. The study has also given leave my lord to file my lord.
You have served them.
Yes, I have served my lord.
নিয়ে নিন দেখি কোন দিন দিতে পারি। নিয়ে তো নিন। I can't help that. Give it. Let us see.
May it please your lordship kindly allow me to praying inclusion under the heading
Keep
motion.
a watch on the list. See when it appears.
May it please the lordship kindly allow me, I'm praying for inclusion as under the heading motion. This is
Please
group one
keep
land
these
matter.
slips for inclusion. Just for inclusion, please don't mention. I have already said that.
Grateful.
And don't expect it to appear the next day, because it will take some time for the files to come. So many files have come from court 5. Yes.
Grateful. Your lordship, may I be please permitted to mention a matter?
This case, there is the pendency of application. Authority over this is a letter for getting them out. And then it prepared the check, as my last week, that you can produce the order, then otherwise. So extremely unusual.
এগুলো তো একটু urgently দিয়ে দিন। এগুলো urgently দিন। Bank account yes.
May I please to mention a matter? This is the written petition filed appearing in the list 459. I am an SEZ unit. I am not subject to any taxes. I have given a representation to the government. My difficulty arises the government has come up with a scheme which is to be ended on 31st of December for all the entry tax issues that no tax payable. Since I am an SEZ, I have gone to the government, said I am not applicable subject to any tax. We given a representation, no answer. They are asking to insisting on an order of the court. I only want my representation to be heard and disposed of.
দিয়ে দিন দিদি ওটা দিয়ে দিন।
Because I have a 31st December.
Urgent, you have given your grounds,
I have
because
put my
it may not get great. দেখুন ওটা আর্জেন্টের আসছে না কেন? Very well, give it to
Lordship, may I be permitted to seek leave? The matter is pertaining to the determination of the Honorable Justice Hiranmoy Bhattacharya, Lordship, that the petitioners are owner of a lorry, Lordship, that six-wheeler vehicles, Lordship. He used to work for the carrier of the sands, Lordship. Now, what happened, Lordship, that after getting the proper permission from the authority, Lordship, they have with the challan, Lordship, they have transported some sands from point A to point B.
আর্জেন্ট ম্যাটার গুলো মিশে যাবে। না আর্জেন্ট দিয়ে দিন। দেখিয়ে নেবেন।
when, my lord, that transportation takes place from the point A to point B, lordship, that the sand has been taken from the point A and it should be dropped into point B. Now, this challan has a valid permission for this period of time, lordship. In the meantime, lordship, he have to transfer the sand, lordship. Now, in the meantime, lordship, when the road is connected, road is going on in the area of the another BLLRO, lordship, that BLLRO, without any basis, lordship, without given a proper notice or proper document, lordship, they have imposed a fine to the petitioner, lordship. Now that there is no documentation, lordship, on the next day when the petitioner further go to carry the sand, lordship, that it has been showing in the system that, lordship, he is not able to permissible
There is
to
no
carry the
provision
sand.
for appeal.
No, lordship, no provision, because we don't have any.
Imposition of fine is appealable order.
But, lordship, we don't have any document to show that there is any fine, lordship. They are saying that you have to pay some amount. They are giving a particular account number to deposit the amount to the account. Only then, only, lordship. Yes, your lordship. On Monday, lordship, can it on Monday, lordship? Grateful to you, lordship.
Listed as 450. An analogous matter is at CJ 22 today of yesterday.
So once it is taken up, you mentioned we'll take up.
And also one extension of entry order, it expired on 30th November. The file could not be traced. Now the file has been traced in the mandamus and so I am paying your significant
extension is
cash scissor I not given us. Once it is done.
My lord, may I be permitted? My lord, may I be permitted to mention one matter for extension of interim order?
Extension, please give. Don't mention extension. Give it.
My lord, may I permit to mention?
My lord.
This matter is today item number 630 in the list, my lord, and the matter regarding 2022 recruitment process, my lord, and the 2024 the merit list published, my lord, and the last occasion affidavit in service and affidavit in opposition is taken by record, and since my lord, yes, since long time the matter is under the heading of hearing, my lord.
Very well. It will be taken up in due course. Yes.
Your Lordship, may I be permitted to mention a matter? This matter was previously mentioned on Monday by my senior, Mr. Nirmalu Dasgupta. This pertains to the Salt Lake property wherein an order of eviction had been made against the petitioners, which was later on appealed before the learned district magistrate, who had upheld such order of eviction and thereafter remanded the matter back to the SDM for filling certain lacuna that had been mentioned in the order itself. However, we had mentioned, preferred this instant writ petition as an appeal before this honorable court, and thereafter the writ petition was heard from time to time. However, the learned SDM, he had adjourned the matter for till disposal of our present writ petition. However, he has so moved to recall his own order and has been conducting proceedings despite the High Court being season of the matter. Your Lordship, if the learned SDM continues to proceed with the
next week, all of these group one matters will appear on one day. You please
the
give.
matter is fixed tomorrow itself before the SGM.
I cannot take it up today.
Your Lordship,
You take adjournment tomorrow. Yes.
Grateful, Your Lordship.
My lord, both are related to my lord retirement benefit. My lord, the urgency of the first matter is, my lord, that alleged overdrawn amount was taken from the petitioner.
You have mentioned your grounds of urgency.
Yes, my lord.
Please give it. Please give it.
May I be permitted to mention?
May I have your
Hearing matter for inclusion, my lord. Not the urgency is that, my lord, the petitioner.
For inclusion, please give. We'll see.
It's a hearing
Yes.
matter.
I have your lordship's kind leave to mention one matter, my lord, for inclusion in the list and the upgrade for upgradation, my lord. But as such, my lord, under compelling circumstances, I'm mentioning virtually, my lord. The issue is that, my lord, in that writ petition, I have challenged the proceeding initiated by the adjudicating authority and the DGGI that being an unregistered person, they cannot issue show cause notice under section 74. Now, my lord, they have issued the personal hearing notice, my lord. If my writ petition is not being heard, my lord, it will be infructuous, my lord. My lord, the writ petition was filed on July 2025. And it was running in the list, my lord.
So you participate in the proceeding. What is the problem?
My lord, only issue is that, my lord, until and unless, my lord, the writ petition is being heard, my lord, they will complete the proceeding, my lord. My lord,
the writ petition is, you have come up with a writ petition at the show cause stage, isn't it?
Yes, my lord. And the proceeding initiated by the entire proceeding, the search and seizure, everything I have challenged in that writ petition, my lord.
Why at the show cause stage should I interfere, madam?
My lord, kindly consider, my lord, the petitioner was an unregistered one. It's a school. It was not liable to take registration.
When is the hearing fixed?
My lord, two personal notices was given, my lord. Yesterday was also another hearing, my lord. There I have given a mentioning notice to that particular officer, my lord. My lord, kindly include in the list, my lord.
include করে দিন, লিস্টে দিয়ে দিন,
My lord, yes.
লিস্টে নিয়ে নেবেন।
My lord, my
include
junior is there, my lord, she is handing over the.
দিয়ে দিন।
My lord, kindly, my
all
lord,
the list.
the petitioner is deprived since a long time. I am praying kindly, my
Very
lord.
well. So the
Kindly,
recruitment
my lord,
process has
just-
been completed. Recruitment result is published in 2024. There is no urgency
But
now.
my lord,
All the
since a long
list
time, the matter is under heading of hearing, my lord.
all. चलो।
My lord, I appear for the petitioner. I am led by Mr. Verma.
Please, my lord.
জলপাই
রেখে দিন, ওটা রাখবেন, দেখাবেন, এটাই মেনশন করেছিল। ওই তো শি ইজ দেয়ার, আছেন তো উনি।
Please, my lords. My lord, this matter was listed yesterday. My lords, a part arguments were being made. Your lordships were of the view that the goods shall be released under section 129 1A given.
Yes, Mr. Agarwal.
I am led by Senior Counsel Sri Ratan Bani. My lords, I would like to place before yesterday, my lords had asked to satisfy the court that why the circular is not circular serial number 6 of the circular is not applicable in this instant case.
Yes.
Yes. My lords, for this I would like to bring to the before the court some of the documents which are already attached in the writ and
yes, please.
And my lord, in brief, I have to in nutshell I am stating that for being applicability of circulars, this circular serial number 6, the document which are to produce before the adjudicating authority or the inspecting authority at the time of the interception should correlate and support the goods which are being transported.
Right.
They should relate to each other, but that means, my lord, goods which are being transported should relate to the documents which are being produced.
Yes.
My lords, may kindly take to the page 88 of this writ application, my lords.
Page 88. Yes.
My lord, the goods were intercepted on 11th July 2025.
11th?
11 July 2025.
25. Right.
11 July 2025.
And
yes.
my lord, the invoices which they are producing for their purchase invoices are dated 28th of July 2025.
Yes.
Right.
This is the first point I am pointing out, my lords. Again,
That is only one.
Thereafter,
take to the
89.
page, my lords.
Yes.
It is an e-way bill generated. It is dated 28th of July 2025.
Yes, I have noticed that.
When they have purchased these goods on 28th of July, how that goods appear to be intercepted on 11th of July 2025?
My lord, kindly take page number 90
My lord,
as well.
my lord, please let me submit.
Yes.
This is the first contention. Secondly, my lords, my learned counsel has yesterday relied upon the judgment of our division bench, on page 215.
Page 215. Yes.
My lords, in page of in this judgment, there was no discrepancy. There was no discrepancy in the goods. My lord, may kindly take to page 216, para 4 and 5.
Yes.
The following facts are not dispute. There is no dispute regarding that purchase.
Right.
No discrepancy in the goods, my lords. The following
Para
facts.
4, yes. The facts are not in dispute. Yes, I have noticed that.
And in our case, there is a discrepancy in the goods. My lord, may take to page again. Take to the page
88.
148, my lords.
148.
148, my lord.
148.
Para 3, A and B.
148. Para?
A and B.
Yes, 3A and B.
A, there is a discrepancy in the quantity of goods of 1300 kgs.
Yes.
And secondly, in para B, they are not establishing this where from them they have procured this goods. No corresponding e-way bill, inward e-way bill was found.
Yes.
My lords, may again, he have already also relied on the judgment of ASP, that is page 178, my lords.
Page 178. Yes.
Para 14, my lords. It is in the second last line. They did not find any description in the genuineness for the discrimination of the goods of conveyance with the e-way bill. There was no discrepancy in the goods and the e-way bill.
No discrepancies found in my case also, sir.
Yes, sir. Let him submit.
Yeah, no issue, no issue.
Yes.
My lords, I will, my lord, may I read this page 216, para 4 and 5 for my convenience, my lord?
I have read that. 16, para 4 and 5 I have read.
And my lord, again may take to the MOB 9, para 10.2.
Page?
Page, my lord. It is page.
Allotted page 152. It's page 152.
152.
On the basis of evidence.
Page 152.
My lord, in para 10.2, it has been specifically mentioned the invoices submitted are not enough to prove the genuine procurement of the goods. They are some random invoices appear to be procured in haste after issuance of MOB 7 dated 24/7/2025.
Yes.
And furthermore, the statement of the driver which was recorded in which has been stated in page 148, para 2.2, my lords.
Statement of?
The driver.
Driver.
Statement of driver. Yes. Page?
He stated he has just parked the vehicle in front of godown for loading of goods. There was no signboard displayed in the godown.
Which page?
Page 148, my lord.
148.
148, my lord.
1.2.
2.2.
2.2. Summons.
2.2, yes.
In the third last line, my lord, further he stated that he just parked the vehicle in front of a godown for loading of goods. There was no signboard displayed in the godown.
Yes.
This creates a great suspicion, and it brings out that they are transporting this goods from where they have procured. They are not able to establish. They are supplying this dried Erica nut procured from other sources, evading the duties and reflecting under their own GST, only using the own GST credentials to transport the goods which are not procured from the proper means. My lords,
Yes.
he may be an opportunity to prove his ownership before the appellate authority.
But in the interim, why can't you release the goods upon him paying that? That will be decided. You will be entitled to realize that.
My lords,
this is not going to prevent you from realizing the final amount that you arrive at, or from keeping the same amount and holding him liable to it.
No,
for the interim, why can't that be done?
I am not against the release of goods. My lords may kindly takes that 128 to 1A, the amount of penalty is just 10%. Amount to be taxed And in
One
129,
twenty-nine.
My lord, he's referring to 129 clause A.
1B.
The penalty is 10%, and whereas in B, the penalty is higher.
Is
That I
100%.
understand, but according to your
My
circular,
lord,
prima facie,
my lord, he may deposit the amount in 129 1B. He may appeal if he
Why?
gets he may get the refund, my lord. There is no bar in taking the refund. I am
My lord,
ready
why
to
not in
release.
129.1? All points let that be open for the
in
appellate court
terms
to
of the
decide.
circular, once the consignee or the consignor's name matches with that of the documents, then in that case, goods you at prima facie you are to treat that person as owner, and you are to release the goods. So you release the goods. Mr. Verma,
Yes, my lords.
why don't you secure the balance sum by way of bond?
No, my
Yes.
lord. Though under the
129.
GST, the
Because
only
see,
issue, my lord.
Mr. Verma, even my reading of the circular is that the circular will not override all such situations where the genuineness of the transaction is in doubt.
My lord, it will override. It will
Genuinely.
It will
override.
not.
That is
It
my
definitely
intention.
can't. It
My lord,
definitely
for a
can't.
moment, my
Then
lord,
this
for a
makes no
moment,
sense at all. Then section 129 1B will have to be wiped out in all
Yes,
cases.
my
yes,
lord, I'll substantiate.
The invoice that you produce has to be taken as sacrosanct.
No, my lord,
Is that what you are going to submit?
may have page
It
155.
is not subject to scrutiny. The
My
invoice
lord,
that you are the
may have
invoice that you will produce, Mr. Verma, let the court speak
Yes,
first.
yes,
The invoice that you are producing will not be subject to scrutiny merely because you come with an invoice which contains the consignor's and consignor's name. The authorities have to shut their eyes, treat the instruction as some kind of a statute, and put away all the inquiries that they can undertake. Is that the meaning of the circular?
My lord, I'll just explain what's the scope of 129 read with section 68 and rule 138A. My lords, under the GST Act, these sections 129 starts from where my goods originates till their destination it reaches. In between, if they intercept my goods, their only duty is to ensure that my goods are in consonance with the tax invoice or not. If it is in consonance with the tax invoice, they cannot proceed under 129. They have to release the goods under section 68, read with rule 138A. If they are not in consonance, in that case, they can invoke the penalty. Invoke the penalty under two circumstances. If the owner does not come forward, ownership, the CBIC has clarified, the division bench of this honorable court has followed it. Even the Allahabad High Court, Pooja, please give Halda.
The division bench of this honorable court had decided the issue in the light of a fact where there was no dispute as regards the ownership of the goods.
My lord, there was complete
Your
dispute.
supplier is suspect. That is under suspicion.
My lords may have
not
Allahabad.
satisfied to that.
No, division bench, there is a statement of the owner that I am not the owner. That is also the worst situation, my lords.
You kindly read the paragraph which was placed just now.
Yes, my lord.
216.
Yes, my lords.
See page 216, paragraph 4.
My lords.
Please read paragraph 4.
Moreover,
has
that
purchased
judgment was on 129 1B. That judgment.
Please
division
wait,
bench.
Mr. Bonik, please wait for your turn.
Yes.
Yes, Mr. Verma, please place paragraph 4.
Number 1 has purchased ready-made garments from Messrs.
No, before that, the following facts are not in dispute. Therefore, this was not in dispute as to where from you had purchased or the appellant before the court had purchased. Here it is in dispute.
No, my lord, there is a difference. There is a difference your lordships may see. They have not considered, my lords may have page 155 of my petition. The fact doesn't even remain, my lords, once I paid the tax on it.
155.
My lord, it's GSTR 1. That is my outward supplies. Outward supplies for this month on which I made the sales. Now, my lords may have page 162. I have paid the tax on it in my return also.
162.
Yes, my lords. I have paid the tax on this invoice also.
My lord,
GST return. 162.
No, but this invoice of yours, the goods that you have shown to be there in this invoice does not match with the verification. Your goods are in excess of what you have shown here.
That's why they can impose penalty under 129 1A. That is what my contention is.
Dispute because the consignor, the details of the invoice are not matching.
No, everything is matching. Invoice number matching, invoice name matching,
Not
everything
matching at all. If there is an excess of 1300 kilograms, how can you say that it
There
is
is no
matching?
excess, my lords. May have annexure P12. P12, my lords, it's at page 121. This is by the West Bengal government. Once my goods entered into the state of West Bengal, it's been conducted, the payment has been conducted by the state of West Bengal. It's exactly matches with the tax invoice. Everything matches, my lords. It cannot be at the whims and fancies of the
Page
officer.
121, my lord.
175, page 175, my lords. Annexure P21. Page 175.
75.
Yes.
Yes.
This is a payment slip that has been given to me once I entered into the state of West Bengal. It matches with everything. My lords,
Yes, Mr. Agarwal, then how do you arrive at the conclusion that it is 1300
My
kgs
lord,
more?
My lords, it was at the time of physical verification, the payment was done, my lords. This is the payment slip which they are producing. They are saying this is the payment slip when they are entered into West Bengal. But at the time of physical verification on 11th of July, not on 11th of December, my lord.
Physical verification
On 14th of July, my lord. It was found that at the payment at the customs office, it was found to be excess, my lord. How the material will become excess after entering to West Bengal and during this small transit period, how the material will exceed the which payment which they have.
The government.
That's the suspicion, my lord.
my lord, but how does it matter? If he imposes a penalty on me, he has not applied his mind on all the documents. My lords have seen the
That will be tested by the appellate authority. Here
My
I am
lords,
only concerned about this ownership part.
ownership. That is what I'm saying, my lords. For the ownership, my lords, the legislature has specifically carved out a provision
Not the
that
legislature. It is not the legislature.
it's my lords, circular. It's a circular.
It is a circular binding only on the
Binding on the avenue, my
and
lords.
that also if it is within the framework of the statute.
Yes, my lords.
It does not go that far and say it is legislature's
My
document.
lords, this circular categorically binds them.
My lord.
My lords, even the Allahabad High Court judgment that I have given, my lords, Halda Enterprises, Halda Enterprises, Allahabad High Court.
My lords, may I submit, my lords?
My lord, this is a very specific, even in a state of Uttar Pradesh, my lords, these authorities are detaining the goods only on this ground. And
The Allahabad judgment of Ram Enterprises says something else that you have annexed at page 189.
Halda, my lord, Halda.
Your document at page 189.
Yes, my lords. My lord, that follows Halda only. That follows
page 190, sir. Please come to page 190.
Yes, my lords.
Yes.
From
Now
the
paragraph 3.
The Revenue Authority have not challenged that invoice and e-way bill produced by the petitioner.
So what does this mean? What does this mean? That if the e-way bill and the invoice is suspect, then in that case this circular may not apply.
No, that they have not challenged. May have the show cause.
They have in a sense said that
quantity, the payment of the quantity.
No, not only that. They also say that you are not the owner in a sense.
My lords, make this point. There are two aspects. One is that the tax invoice and a e-way bill has been generated.
It was just now submitted that the invoice is not matching.
No, my lords, he's wrong. I'll substantiate, my lords. The invoice number matching, invoice name matching, consignee name matching, everything is matching, my lords. May have
quantity not matching, my lords.
This is a very wrong statement, my lords. I'll substantiate. My lords, may have page 48. The show cause notice itself categorically states.
Page 48.
Yes, my lords. The first, on being asked the driver of the goods conveyance, name this and this, produce the invoice number, dated this, matching, which they have intercepted, issued by the consignor JJ Traders, that is me, to this place, my lords, to the consignor, to the consignee name is also matching, address, consignment note is also matching, and which I have produced against the show cause notice also, that they have not doubted the veracity. The question of ownership does not arise in that case. They have exactly, my lord, they have only questioned my inward supplies, not my genuineness of my text invoice or e-way bill or
Inward supply, you will claim ownership only if you have got it in accordance with
my
law.
lord, that I have produced, but he has not examined. That is what I have produced. All
He has
invoices of-
examined, he has returned the finding which is not palatable to you. That is different.
No, my
But
lord,
that you can't say that inward supply is not
supplies,
important
my
at
lord,
all.
inward supplies is otherwise beyond his scope. Section 68 doesn't allow him to do that. That is my jurisdictional officer under section 73 or
The
70.
moment the question of determination of ownership comes, inward supply assumes importance. You can't
My
say
lord,
that
that
it
is
is
why
not within his domain.
a clarity has been given by the CBIC that a deed owner has
Clarity of CGST will apply only in cases where there is no dispute as regards the facts of the case. Here there is a dispute which is patent.
My lord, they have not doubted my tax invoice and the e-way bill and the consignment of
They have
only the quantity.
doubted your procurement. They have doubted your
My lord,
procurement and hence your ownership.
My
My
lord,
lord,
that
can I
is
submit-
beyond the scope of Rule 138. My lords may have Rule 138A in that case. Rule
My lord,
138A.
I submit, my lord.
Sir, let me just complete, please.
Rule 138A.
My lords have it.
Yes,
The
yes.
person in charge of the conveyance shall carry the invoice or bill of supply or delivery challan, as the case may be, a copy of e-way bill in physical form or e-way bill number of in electronic form, or mapped to a radio frequency identification device embedded on to the conveyance in such manner as may be notified by the commissioner. So, my lords, as far as Rule 138A is concerned, when my goods are in transit, I am only required to carry on the three documents, that is tax invoice, e-way bill, and the consignment note. Beyond that, I am not required, and all the three documents has been provided to him. He has not questioned.
You are not required in usual course of things. That is all very good. But if something is suspected merely because you are carrying an
That is,
invoice,
my
that
lord,
will be
that's
treated
why,
as binding on everybody. That cannot be the law.
my lord, that's why clarification has been given that yes, without prejudice to the person's right under 107, he can file an appeal. But if his name is there in the consignment note and the tax invoice, he may come and give the penalty under 129(1)(a) and let him file the appeal and let him prove all the discrepancies that are there in the show cause notice and the order. This has been consistently followed by my lords by each and every high court. That's why I place
For
the
me, that is the facts of this nature. It has been followed. All the judgments that you have shown are absolutely on different facts where there was no dispute of any kind of the nature which is involved
My
here.
lord, if these interpretation has been taken into consideration, my lords, the free
This
movement of
interpretation has always to be taken in the context of the text.
My
You
lord,
cannot
it will restrict the free movement.
interpret anything out of context.
My lord, it will restrict the free movement of goods for everyone. It will restrict
And it will allow everybody to claim ownership of the goods merely on the basis of a document which cannot be tested according to you.
My lords, because the Rule 138A only obliges to carry on this
Rule
document.
138A is to be looked at from the angle that the documents are out of dispute. If the documents are disputed, Rule 138A will not save you.
Yes.
Then there will be no case of fraud at all.
In that case, the proper officer appointed under Section 129 will exceed his power, and he will adopt the power conferred under Section 73 and 74 and Section
That he
65.
will do, but at this stage
That is beyond his scope.
why should you not do this?
Now,
Why should
my
you
lord,
not do this? I'll direct release of the goods upon you paying in terms of 129(1)(a), but you will have to secure the balance sum.
Yes, my lord, I'll secure the balance. I'll secure in my bank account. The balance I'll give them. I have no.
That is what I was saying from the very beginning.
I apologize.
There was no reason for you to argue then.
I
at the very beginning. You
I
secure
do.
the.
I will immediately pay under 129(1)(a), and remaining amount I will secure in my bank account, and I'll give them that this is the amount I secure. I have no issue, man. I have no issue.
Mr. Agarwal.
Yes, my lord.
Your sum is secured.
He may submit by bank guarantee or a bond, my lords.
No, not by bank guarantee and bond, my lord. Bank guarantee.
My lord, bank guarantee as is specified in the statute, my lords. Bonds and a bank guarantee.
I'll give them a bond along with the amount.
No.
put it in my bank account, that please take it along with the bond.
My lords, may
You
kindly
secured the interest of the avenue.
My lords, they may secure it by the bank guarantee or a bond, my lords, as it is in the statute also, my lord.
Yes, Mr. Agarwal, in terms of Rule 140.
Justice Go may be released on a provision on his own bond for the value of the goods and furnishing of security in the form of bank guarantee.
For the convenience of the court, my lords, I have very clear instruction under 129(1)(a). I am ready to pay the whole amount, and the remaining amount I'll give a bond, not a bank guarantee, my lords. Along with the amount, I'll secure it for the avenue, and I give my undertaking that it's secured for the avenue till my first appeal gets disposed of. If it goes in my favor, nothing remains. If it goes against me, I'll pay it to the avenue.
Then why not in the form of a bank guarantee? What is the problem there?
My lords, the bank guarantee, all the amounts will remain with the department. It's very difficult for me to get the refund from them in that.
Bank guarantee,
My lords,
bank guarantee, you are not required to pay any amount. The bank will give a guarantee in your name. That's all.
so, my lords, for the remaining amount, I'll give bank guarantee for
Yes,
the.
bank guarantee, it's not that you will have to deposit that amount. That is not the concept of bank guarantee.
So, my lords, 129(a), when I am ready to pay.
Yes, 129(a) you will pay. You
Bank
submit
guarantee.
the bank guarantee for the balance. You
Yes,
will
my lord.
secure. Very well. Likhen it. And I am relegating you to the appellate forum.
Yes, sir. My lords, in that case, my lords, since my amount will be under in view of that bank guarantee.
I direct the appeal to be disposed of.
Within a
Within a specific period. Within a specific period.
time.
My lords, it's
All right,
already specified 1 year is the time frame, my lords.
My lord, 1 year is
1 year is very good, sir. Just consider that there is a financial problem.
already this vehicle has been held by them for last.
My lords, in one of the matter that I argued
Three
before the
years
Honorable Division Bench, Justice Shampa Sarkar, in that case, it was decided that the appeal may be disposed of within 6 weeks once I file that appeal.
I'll direct that. I'll direct that.
Much on that.
My lord, it may also be guaranteed that they may not take the adjournment in the meantime, my lord, for necessary reasons, my lord.
I will not take any
adjournment.
adjournment. I give my undertaking. I will not take any adjournment.
They will not get
Yes.
any return. Right.
Yes, I'll record that. This writ petition lays challenge to an order dated July 31, 2025, passed by the respondent number 2, i.e. Assistant Commissioner within brackets capital HAEU bracket closed, comma Central CST and CX, comma Siliguri, whereby the where is the impugned order? Page 152 was the
Order
whereby
one.
the penalties have been imposed upon the petitioner under section 129 within bracket 1 within bracket A, as well as section 129 within bracket 1 within bracket B of the CGST Act, 2017 stroke WBGST Act, 2017. Hereafter, the said Act of 2017 bracketed till hereafter. Full stop. it is the case, no, it is not correct. The case run in the writ petition is that the petitioner is a dealer is a dealer of areca nuts and has been conducting his business throughout India. Full stop. On July 8, 2025, the petitioner sold 17,550 kgs of areca nuts to one MS Surana Supri SUPRI Center situated in Nagpur, Maharashtra. Full stop. On July 11, 2025, while the goods were in transit to Nagpur, Maharashtra, the respondent number 2 intercepted the vehicle containing the petitioner's goods at Huslu Danga Toll Park, Huslu HUSLUDANGA Toll Plaza, Jalpaiguri. Full stop.
নামটা দিয়ে দিও আমার।
Thereafter, an order in GST MOV 02 was passed. Now, the goods were physically verified and form GST MOV-02 was issued. Full stop. On July 14, 2025, a physical verification report in form GST MOV-04 was issued, indicating therein that there was a difference of 1300 kgs in the weight of the goods disclosed in the tax invoice and the actual weight of the good weighed by the authorities at the time of physical verification. Full stop. Please correct me if I'm wrong. Full stop. Paragraph. On July 14, 2025, a summons under section 170 was issued by the respondent number 2 to the driver of the consignment, directing him inter alia to tender written statement and produce documents. Full stop. On July 17, 2025, an order of detention of consignment under section 129 within bracket 1 of the said Act of 2017 was passed. Full stop. Subsequently, on July 24, 2025, a show cause notice in form GST MOV-07 was issued by the respondent number 2 to the petitioner under section 129 within bracket 1 within bracket A. Now, imposing penalty to the tune of rupees 3,57,200 under section 129 within bracket 1 within bracket A, as well as penalty of rupees 35,72,000, under section 129 within bracket 1 within bracket B, on the allegation that the petitioner's supplier on the allegation that the petitioner's supplier was dubious.
My lords, it's not that the petitioner supplier was dubious, he was not able to establish the genuineness of the procurement.
Sir, I'm recording what is there in the writ petition. Please hear and then make your comments. Yes. Full stop. Paragraph. The show cause notice also alleged that there was a difference in weight to the extent that there was excess weight of 1300 kgs of goods found upon physical verification, full stop. Now, in comparison with what was declared in the tax invoice, full stop. Paragraph. The petitioner filed a reply to the said notice to show cause through email, reaffirming that there was no difference in weight as alleged, and that the driver's statement that the driver had no idea about the consignor or the transporter involved, or that the petitioner's supplier was dubious, was incorrect. Full stop. The petitioner furnished all relevant details in the reply, along with copies of purchase invoices and e-way bills, bank statement, stock report, and GST registration certificate in support of the petitioner's contention. Full stop. Paragraph. It is the further case of the petitioner that on July 29, 2025, the petitioner was present in the office of the respondent number 2 along with his authorized representative to explain the factual matrix of the case and avail of the opportunity of personal hearing, but such personal hearing was not afforded, and ultimately the order impugned was passed on July 31, 2025, rejecting the petitioner's reply dated July 28, 2025, filed in response to the show cause notice. Full stop. Hence the writ petition. Full stop. Paragraph. Mr. Verma, learned advocate appearing for the petitioner, submits that the order impugned has been passed in total derogation of the principles of natural justice, inasmuch as no opportunity of personal hearing has been granted to the petitioner despite the petitioner being present in the office of the respondent number 2. Full stop. It is further submitted that the respondent number 2 has passed the order without proper consideration of the documents produced by the petitioner along with the reply to the notice to show cause. Full stop. Mr. Verma further submits that the order impugned is in any case liable to be interfered with, inasmuch as the respondent number 2 has illegally invoked the provisions of section 129 within bracket 1 within bracket 2 within bracket B of the said Act of 2017, when the petitioner, whose name figures as the consignor in the invoices as well as in the e-way bill, has himself owned up and come before and seeks release of his goods without prejudice to his rights to challenge the same, challenge the order impugned before the appellate authority. Full stop. Paragraph. In support of his such contention, Mr. Verma relies on the circular relies on a circular dated December 31, 2018, issued by the Central Board of Indirect Taxes and Customs, wherein it has been clarified that if the invoice or any other specified document is accompanying the consignment of goods, then either the consignor or the consignee should be deemed to be the owner. Full stop. In support of his submission, Mr. Verma also relies on a judgment of the Honorable Division Bench of this court in the case of Sandeep Kumar Pandey, page 215. Page 215, delivered on 7/8/2020. Full stop.
My lord, page 215.
Yes.
My lord, page 215.
What?
Judgment is on page 215. My lord.
Yes, yes.
Yes, my lord, I've noticed that.
Yes. Mr. Verma also relies on a judgment of the Division Bench of the Honorable Allahabad High Court in the case of AETM for the same proposition. Full stop. Paragraph. Mr. Verma, that's all?
Yes, my lord.
You are not audible.
Yes, my lord, I believe
My
yes.
lord, for the principle of natural justice part, I relied on Supreme Court judgment of ASP traders.
Yes. Mr. Verma further submits that in terms of the judgment of the Honorable Supreme Court in the case of
ASP traders.
Page?
Page, my lords, 176. My lord.
190.
190.
96. I think 196.
196.
Or
176 ASP.
176.
Yes,
My
sir.
lord.
no.
196.
96.
76.
196 or 76?
196.
No, 196 is something else. State of Kerala.
My lords, page 200. Page 200. ASP traders.
Page 200.
Relevant is at page 209. Sorry, 213. True, 213. Relevant is at page 213, paragraph number 18.
In support of his contention that the final order in form GST MOV-09 must be passed only after granting an opportunity of being heard. Mr. Verma relies on the judgment of the Honorable Supreme Court in ASP Traders versus State of Uttar Pradesh, reported at 2025 176 taxman.com 782 within bracket SC. Full stop. Mr. Agarwal, learned advocate appearing for the petition for the respondent GST authorities, submits that in the case at hand, the petitioner has not been able to demonstrate that the petitioner has procured the goods, i.e. areca nuts, that he is now purporting to sell from genuine suppliers. Full stop. It is submitted that based on the statement of the petitioner's driver, it has been found, and as well as the absence of inward e-way bill for goods, coupled with the fact that tax invoices relating to purchase of the goods, alleged purchase of the goods by the petitioner from his supplier, evince dates post the interception of the vehicle, comma, it has been found that the petitioner may not have procured the goods and may not be the owner thereof, and the petitioners and the genuineness of the petitioner's suppliers is in doubt. Full stop. Paragraph. It is further submitted that the circular dated December 31, 2018 is to be applied only in cases where the invoices or the specified documents accompanying the consignment are absolutely in order. Full stop. It is submitted that in the case at hand, although the invoice and the e-way bill show that the weight of the consignment was where was that finding?
My lords, in page 148. Page
148.
Para
Yes,
3A.
that the weight of the goods as per the invoice was 17500 kgs. Yet, upon payment by the GST authorities at the time of verification, the same was found to be 18800 kgs. Full stop. Since there is a discrepancy in weight as well as there is doubt as regards the genuineness of the petitioner's suppliers, the circular dated December 31, 2018 cannot be resorted to by the petitioner. Full stop. Paragraph. It is further submitted that and what about this contention of the petitioner that he was physically present and he was not heard?
In page 55, he sent an email on 31st of July, my lords. In that, he is submitting the further documents, but he is not objecting to that he was present, or he is not even specifying any words regarding that thing. If he would have been in the office,
as regards the petitioner's contention that the petitioner was not provided an opportunity of being heard, comma, it is submitted that the same is false, inasmuch as immediately after the date of hearing, comma, the petitioner issued an email dated July 31, 2025, within bracket, page 55 of the petition, thereby attaching tax invoice and e-way bill, sent an email to the respondent GST authorities, thereby attaching tax invoice along with e-way bill, but no contemporaneous objection as regards non-affording of opportunity of personal hearing was ever raised before the authorities. Full stop. It is submitted that the stand now taken by the petitioner is an afterthought. And the same is incorrect. Full stop. Paragraph. Heard learned advocates appearing for the respective parties and considered the material on record. Full stop. আচ্ছা, একদম উপরে মিস্টার আগরওয়ালের সাবমিশন কালকে যেটা লিখেছে বলেছিলেন এটা এক জায়গায় লিখে দিন। মিস্টার আগরওয়াল further submits that this court should not intervene in this matter under Article 226 of the Constitution of India, inasmuch as the petitioner has an alternative remedy in the form of appeal before the appellate authority under Section 107 of the said Act of 2017. Full stop. Paragraph. Heard learned advocate appearing for the respective parties and considered the material on record. Full stop. It is now well settled that existence of an alternative remedy does not bar entertainment of a writ petition if it can be demonstrated that the case with which the person has approached the writ court falls within any of the four categories, i.e., any of the following categories, i.e., violation of principles of natural justice, infringement of fundamental rights, challenge to vires of a statute, and an action palpably divorce law. There are others also I will incorporate.
Jurisdiction.
Yes, jurisdiction.
One full principles. Next. In the case at hand, although the petitioner has alleged that the petitioner was not given personal hearing, the aspect as to whether or not the petitioner was, although he was not given personal hearing despite the petitioner being present in the office of the respondent number 2, such aspect would require an inquiry into facts in order to ascertain the veracity of the petitioner's statement. Full stop. Such exercise cannot be concluded on the basis of affidavit evidence in a writ proceeding. It is not the petitioner's case that no notice of personal hearing was served upon the petitioner. It is rather his case that in terms of the notice, he appeared before the authorities, but the authorities have not heard him. Full stop. Such aspect would require a deeper probe, and that can well be undertaken by the appellate authority under section 107 of the said Act of 2017. Full stop. The court has gone through the order impugned. It appears that several factual issues are involved. Full stop. Precisely, the same, once again, may not be adjudicated by way of affidavit evidence in writ proceedings. Full stop. Eta একটু quote করে দেবেন page 148 এর several factual issues are involved যেখানে লিখেছেন না ওখানে লিখে দেন যে in such regard the following portion the relevant portion of the order impugned in this writ petition is extracted here and below বলে page 148 paragraph 3ab আর এই পুরো এই ঠিক আছে 148 149 148 149 এবার প্রিসাইসলি আর দরকার নিচে চলে আসুন in view of the aforesaid findings, it would not be proper for the writ court to intervene at this stage, and the petitioner should be left free to approach the appellate authority in terms of section 107 of the said Act of 2017. Paragraph. However, since it is the petitioner's case that the petitioner deals in areca nuts, which has a short shelf life, shelf life, and the same may not be fit for use if they are kept in detention for long, comma. This court is of the view that on the basis of the clarificatory circular issued by the Central Board of Indirect Taxes and Customs, circular dated December 31, 2018, issued by the Central Board of Indirect Taxes and Customs. If the petitioner pays the penalty in terms of section 129 within bracket 1 within bracket A of the said Act of 2017 and furnishes security in the form of bank guarantee of the balance sum as determined in the order dated
31/7/2025.
37.
31/7.
31.
order dated July 31, 2025. The petitioner's goods should be released. Acha, bank guarantee for the balance sum, comma, the respondent GST authorities should release the petitioner's goods. Full stop. Paragraph diye likhun. This court has taken this view in view of the peculiar facts of this case, where the authorities have reached a conclusive finding that based on the material on record that the petitioner would be procuring and supplying dried areca nut from unknown sources and reflecting the same in the petitioner's reflecting the same এখানে copy করে দিন under his own firm under the guise of their own GST credentials and bills. Page 149 4.1 এর just উপরে আছে, underline করে দিয়েছি। লিখে দিন, লিখুন যে it is undoubtedly it cannot be doubted that a circular issued by the Central Board of Indirect Taxes would be binding on its officers, but at the same time it is also beyond doubt that a circular has to operate within the statutory framework. The circular has to be read in the context of a situation where there is no doubt raised on the genuineness of the consignor and the transaction. Full stop. Paragraph. In the case of Sandeep Kumar Pandey and another Supra, comma, the Honorable Division Bench had applied the circular in a case where the purchase done by the appellant before the court was not in dispute, and the description of the goods, and there was no discrepancy as regards description of the goods. Full stop. In the case at hand, the authorities have doubted the existence of the supplier of the petitioner and have cited discrepancy in weight of the goods. Full stop. Paragraph. In the case of Haldar Enterprises Supra 2, TOO, 2, there was no case where the genuineness of the transaction of procurement of the goods by the person concerned from its supplier was doubted. Full stop. Paragraph. The principle of law laid down by the paragraph by the Honorable Supreme Court in the case of ASP traders is salutary, but in the case at hand, at this stage, without conducting any factual inquiry, it cannot be stated that the petitioner was not given any opportunity of being heard. Full stop. For all the reasons aforesaid, comma, WPA 2144 of 2025 is disposed of by leaving the petitioner free to approach the appellate authority under section 107 of the said Act of 2017 by filing an appeal against the order impugned. Full stop. This I will bring later on, the release part.
Yes,
I'll
sir.
cut it and bring after this, because
Yes.
this would have gone up. So I'm not disturbing it now. It will be there in the order later on. And नीचे लिखे दे.
One small submission, my lords. In one para, my lords have in order stated that the amount of 129(1)(a) is to be deposited and the balance amount is to be
secured by bank guarantee.
In the form of bank guarantee. The
Yes.
balance amount may kindly be specified at
Mentioned, right.
129(1)(b).
I have the
35.
instructions,
I'll have
my
to
lord. I'll
calculate it.
comply.
Balance amount in terms of the order. In terms of the order, I'm going to do that calculation. You do that calculation. Do something
All-
yourself.
My lord, in terms of 129(1)(b), if it is not specified, they have in the order they have also specified 129(1)(a) and B. They have, because when the owner comes, 129(1)(a) is applicable, 129(1)(b) is applicable, when he is not the owner, my lords.
My lord, it is
Balance
in
amount will-
page number 151, 35,72,000. Already calculation has been made.
My lord, in terms of the order, we will deposit. My lords may record my
But
statement.
that my lord need not go into
Amount,
There are three amounts mentioned there. 129(1)(a) he will pay, and the balance he will secure by way of bank guarantee. What is the problem?
That's only, my lord, the amount may be.
And the balance amount, as
30.
indicated in the order dated
31st July.
July 31, 2025.
right.
That will do.
That will do, my lord.
My
That
lords,
is understandable.
I have the instruction. We will
Balance amount
deposit it by tomorrow.
129(1)(b), my lord, only this much.
Huh?
We will deposit it by tomorrow only.
Yes. What is Mr. Agarwal saying?
Yes,
My lord, balance amount in terms of 129(1)(b), only this is the
129(1)(a).
I have stated balance amount as stated in the order. That is not sufficient.
My lord, the balance amount will be ambiguous if the 129(b) is
Why will it
mentioned
be
regarding the.
why will it be ambiguous? Why will it be ambiguous?
Because there are 4 persons to be deposited, owner,
It will not
this
be ambiguous.
and
If
the
it is
lot.
ambiguous, I'll clarify when I read the order. Please don't interrupt in between of dictation.
Grateful, my. Grateful, my.
If such appeal is filed within a period of, when will you file the appeal?
My lords, within 1 week. Within 1 week.
Within a period of 1 week from date.
One small interruption. Regarding the vehicle conveyance, release of conveyance, my lord.
That may be done, my lord, immediately.
I can't hear him also. What is your problem, Mr. Agarwal? What do you want?
My lord, release of conveyance, my lord.
My lord, he is saying.
Regarding release of conveyance also, there is a of around 2 lakhs rupees, my lords.
Vehicle will automatically include, sir.
So,
Vehicle
together with the
is already
goods?
included in that.
I am
My lord,
unable to
goods
hear
will
you and
also
understand.
include the vehicle. He is saying ki for the vehicle, that should be separately mentioned. The vehicle should be released with the goods.
Vehicle is always
Goods
part of
automatically
129.
Take a clarification thereafter. 1 week, comma, the same shall be decided in accordance with law within a period of 6 weeks.
4 weeks, my lords. May recorded 4 weeks. I won't take any adjournment.
4 weeks.
I won't take any adjournment.
Without granting any unnecessary adjournment to the petitioner. Full stop. Paragraph the लिखून. It is clarified that this court has not gone into the merits of the petitioner's case, and all points are left open to be decided by the appellate authority strictly in accordance with law, without being influenced by any observation made herein above.
Much obliged.
My lords, my lords may record my contention that if I pay the amount, the 129 1A penalty and the remaining amount within 2 days, the same shall be released within next 2 days. That is a practical.
My lord, the vehicles need to be released.
If the petitioner if the petitioner pays the amount of penalty determined by the order dated
31st
July 31, 2025 under
Under
129 within bracket 1 within bracket A of the said Act of 2017 and furnishes security for the balance sum determined under section 129 within bracket 1 within bracket B of the said Act of 2017 in the said order, comma, the respondent GST authorities shall release the petitioner's good along with the vehicle. Satisfied?
Yes, my lord.
My lords, regarding the vehicle, there is a separate
vehicle you drive
penalty
along with the vehicle
2 lakhs rupees,
within 2 days upon payment of such penalty and furnishing of such security as aforesaid.
And provide the GST credentials to enable us to file appeal, my lords.
Yes, my lord, that is another difficulty which we will face.
Difficulty. The
If
difficulty,
GST
my lords.
credentials are not given to us, we won't be able to file the appeal.
My lords, what happened
They
is,
don't give.
lords, I am a registered dealer in Assam. So if I have to file an appeal in West Bengal, since the impugned order is passed in West Bengal, I have to take a temporary GST ID and password from the officer. So there is a 1 week time has been given to me. Let the officer provide me that GST ID and password so that I can file the appeal immediately.
You cannot avail it, or you cannot. I don't know the procedure. You
My lord, we can't avail it ourselves.
They don't give us for 2 to 3 weeks. That is the main issue.
It is clarified that the respondent GST authorities shall facilitate the petitioner's filing of the appeal by providing GST credential,
GST ID and password, temporary GST ID and password.
Temporary GST ID and password for the purpose of lodging of the petitioner's appeal.
Yes, my lord. Within 2 days. Yes, my lords.
Grateful.
Obliged. Deeply obliged, my lord. Deeply
Thank
obliged.
you.
So these two matters, item number 1 and 2, have come up at our instance for withdrawal, but there is also an application. So, my lord, I have to take instructions on the application. I was praying that let it come up on Monday, my lord. But because the
Monday or Tuesday?
Not Tuesday.
Okay, Monday.
Because it's the old writ petition, my lord, department has not filed the affidavit
In the
also.
meantime, then I'll also take instructions.
Because
Not today. Not
Fine.
today. Not today, not tomorrow. On Monday, did the receipt.
Well, 1 and 2. I'm grateful.
This is the email, my lord, from the client.
Yes. Release. Sorry. Yeah. Non-procedural. लिखे नहीं? না ওনাকে দিয়ে দিন না, ওই অ্যাফিডেভিটটা ফাইলে রেখে দেবেন। কি কল করুন দিদি, কি করছেন? হলো তো ফুল সেম অর্ডার, সেম অর্ডার। ওই WP নাম্বারটা একবার দেখে নিয়ে করবেন, হ্যাঁ ভুলভাল হয়ে যাবে।
হ্যাঁ 5 হয়ে গেল, 6ও হয়ে গেল।
Great,
6ও সেম। হ্যাঁ 6ও
सेम ऑर्डर।
सेम ऑर्डर।
2 मिनट रुक जाइए, खत्म करके चलते हैं, एक्सटेंशन तक करना है, हम कॉल करूँ।
Item number 7, Mr. Chorare was here, but all of a sudden he felt unwell, dizziness and stomach ache.
You wanted to withdraw this?
No, this is not withdrawal, Terminator. It is
Yes.
it is seven, not withdrawal. It's a credit notice will be done.
দেখুন কি ভুলভাল এসছে নাকি, নন প্রসিকিউশনে দিয়েছেন,
Sign pharmaceuticals
নন
will
প্রসিকিউশনে পুরো হেডিং দিয়ে দিয়েছেন।
9722.
এইভাবে ভুলভাল হেডিং দিচ্ছেন কেন? নন প্রসিকিউশন তো নিচে লিখবেন, যেগুলো নন, উপরে লিখে দিয়েছেন।
Grateful.
Next.
Eight, my lord, I'm led by Mr. Shumitava Chakraborty in this matter, my lord, and I'm praying for release as this bench has no determination, my lord. And this
Oh,
matter
release?
falls under, yes, ma'am.
লিখে নিন এই। Mr. Nag, learned advocate appearing for the petitioner, points out
any inconvenience in future.
Correct,
It's
correct.
our duty. That's why.
Absolutely correct.
We are happy to do the matter.
No, I understand that. It is good that because I may forget.
Yes. No, when I said Lordship, recalled immediately. That's I'm grateful.
Because I matched the name with the face.
Yes. Grateful. Much of that.
Well, I have for the petition. Like for the extension of interim, it was extended till in December 2025.
List of them.
Or until further. There is the order is 27th of March 2025.
लिखे नहीं।
But till date, man, they have not filed any opposition. Man. So 2023,
This matter is appearing under the heading extension of interim order upon being mentioned therefore, FOR, full stop, paragraph. Third
Same as
কল করুন দিদি, কল করুন, সেম অর্ডার করে দিন।
Your Lordship, I'm appearing for the petition, Your Lordship. The interim order is expiring on end of December, Your Lordship. The last interim order is dated 28th of March 2025, Your Lordship.
Affidavit filed.
Your Lordship, it has been filed. Your Lordship, we are praying for extension of time to file the affidavit in reply, Your Lordship.
All of that টাইম এইভাবে লিখে দিন, এটা ওই শুধু রিপ্লাই একটু চেঞ্জ হবে, আগের প্যারাগ্রাফটা ঠিকই আছে। দিস ম্যাটার হ্যাজ বিন
Kindly release the matter. My lord appeared, I think.
here, I had appeared.
The interim order was passed when your lordship was there.
Yes, then I should not. লিখে নিন মনে প্রথম ম্যাটারটা যেটা হলো ওই অ্যাফিডেভিট ইন অপোজিশন সেম এনি ধরুন লিখুন লিখে দিন যে let this matter be released from this list on my personal grounds since in for appropriate orders.
Grateful, madam.
On my personal grounds, লিখে ছেড়ে দেব। Yes.
Your Lordship, similar prayer as in 14, extension of interim order.
Praying for time to file.
Appearing for
This one.
with Mr. চক্রবর্তী আচ্ছা ওখানে চক্রবর্তী না করে learned advocates appearing for the respondents করে দিন same any affidavit in opposition এর দিয়ে দেব next
My lord, item 16, I am appearing online for the petitioner. Unfortunately, your lordship has appeared for Union of India in this matter. Now, we want to do the matter before your lordship, but it's unfortunate on our part.
Item 16, and for the petitioner and led by Mr. Mitra.
দিন
Here's a copy of the order.
লিখে নিন this matter stands released from my list from this list on my personal grounds let this matter be placed before the honorable the chief justice for appropriate orders
Grateful, my lord.
acting
Grateful.
chief yes ঢুকিয়ে দিন ফাইলে এত নেই সারপ্রাইজ হওয়ার কিছু নেই
মানে I'm for the petitioner, my lord.
Acting your lordship, please. I don't know why. The 18, my lord, I am enjoying, my lord, the stay, my lord, till the one that disposal of the requisition. This is the order, my lord.
why is it tagged there was any order of tagging
মানে this is the order copy তে tag করে দেবেন।
it has been tagged since 23rd of April 2025
Why, my lord, I don't know, my lord. I don't know, my lord. My matter is, my lord, to challenge you 168A. And I am enjoying, my lord, the stay.
and this is different
I don't know, my lord. I don't know, 17 is Mr. Mujumdar's act.
মানে the issue is there মানে one of the
no
issue
but
is
the first order dated 4th of December 2024 records let this matter appear under the heading for hearing along with WPA 12071
Still, my lord, no evidence has been filed.
very well
in
sir.
my case also they have not filed in the opposition.
Yes.
68 minutes, we are dependent on the center, whatever center. The matters are being heard before the Supreme Court.
Very well, I'm extending the interim
Yes,
order.
man. Until further order otherwise
ঠিক লিখে নিন তো
16 হয়ে গেছে।
WPA 28152 of 2024 এ লিখুন you are in WPA 28152 of 2024 no or Mr.
But I'm on item number is 17 I'm appearing, my lord.
17 means
28152
28152 of 2024 এ লিখুন ওই যেটা আগে লিখলেন ওইটাই থাকবে এক্সটেনশনটা
I have handed over already, but 1 page of it.
Till disposal of the repetition. Full stop. The same is evident.
December, to the same point 168A is concerned and they have not filed the affidavit, the interim order may be extended till disposal. my lord.
Disposal. ठीक है. लिखे नहीं.
Your Lordship, I'm appearing for the petitioner. Your Lordship, the interim order was passed on 5th of May 2025. Your Lordship, this is also a similar matter where the wires of one notification issued under 168 is challenged.
Order लिखे दिन शुद्ध advocate एর नाम change हो जाए.
The opposition has not been filed, Your Lordship.
I'll grant him.
Great, great.
तो ये कहते शुद्ध Mr. बगाड़िया जगह Mr. अग्रवाल हो जाए. ফাইলগুলো একটু ঠিক করে রাখবেন, যদি অনেক বসতে হয় তখন সময় লেগে যায় ফাইল. I'll come back in 5 minutes.
affidavit service. Number one. Number two, Lordship, next point is that.
Yes.
I believe states also appearing.
Yes. Yes.
Lordship, here this issue is a very narrow compass. Initially, it is a parallel proceeding. প্লিজ বলতে দিন ভাই, আমার পিটিশন জজ সাহেব থেকে আমি
মেরিটে বলবেন, বাট
আমি মেরিটে বলবো না, আপনি কি করে জানেন আমি মেরিটে বলবো? আমি মেরিটে বলার জন্য আসিনি এই কোর্টে, মেরিটে গেলে অ্যাপিলে যাব। My lord, sorry, what I will say he knows, that is very difficult.
Yes.
Lordship, in this matter, issue is only parallel proceedings. My point is that whatever the central tax authorities are demanding, already state tax authorities demanded. I am showing only one statement. To Deven Joseph, Lordship will. Issue is that disallow of the input tax credit on the suppliers. Lordship, kindly look at this statement. Right side is the central tax demand. Left side is the state tax demand. Out of that, Lordship, out of that, Lordship, kindly look at serial number 1, 2, 3. Lordship, got it?
Yes.
All are same figure with the state tax.
Yes.
Then next also same figure. Next also same. Only serial number 9 is different. Otherwise, out of 8 parties, 7 is same amount. Same amount. Only one party is little different. There the central is more, state is less. So when all same 7 parties supply already covered in the state tax show-cause notice, which was issued earlier, and Supreme Court said which show-cause notice issued earlier, that is the starting of the proceedings, and that will be first will be taken into consideration. So, Lordship, this is the point at this stage. I have challenged the other issues in this writ petition. I am not proceeding at the moment. Then let us first decide which show-cause notice will remain.
Yes, Mr. My lord, my first point. Then all writ petitions should have to get there. When the show-cause notice is by that is not annexed with the writ petition. And the judgment which was relied upon by my understanding, that was August 2025. Our order only passed in January 20. Therefore, whatever guidance given by the Supreme Court, we are after passing of the judgment, we are following. Therefore, our order, which was passed long back before in January 25, has got nothing to do with this judgment. Judgments don't lay down law. Judgments only declare what the law is. Law will take effect from the date of the law, from the inaction of the law. But another point, my lord, irrespective of that, my lord, show-cause notice, which my understanding is relying upon, that is not with us.
Only one point, only one sentence. My learned friend earlier occasion helped me. In other words, he had shown from this show-cause notice, I have given intimation to them that same proceedings initiated by the state authorities. He said I have not given further information. Right. The answer
not
is
required because the authorities will from themselves.
Number one.
They will communicate and take information.
And Supreme Court.
Yes, that I'm aware.
That is the point. And if they want, they can inquire. I am giving today also. I am helping, and Supreme Court said I have to cooperate. I am cooperating. I am giving the statement. Let them verify it.
This is at the stage of show-cause. Adjudication order has been passed.
I have challenged the adjudication orders passed by the state in another writ petition. That is also.
That one is prior, or this is prior? The state one is prior.
State is prior. So that is, and state amount is, let's say 1 point. State amount of tax is high, more than that.
So they will gain. If it is parallel, then Mr. Bhattacharya, it can't remain. Give me the number of the state WP.
WP, in my statement also I mentioned first left side.
This is 5169 5170. Three petitions are there.
Yes.
Lichen info. It is submitted by. Will have very well. It is submitted by Mr. Das, learned advocate. Oh.
My lord. Last occasion, my lord, matter was hard, and your lordship expressed views that whether cash can be seized. Number two, my lord, the interim order. Number three, my lord, your lordship expressed views
that reason to believe another point may be hard on affidavit and with some short stay, my lord. It was hard, my lord, last day. And my lord,
Mr. Banerjee, cash, how can you feel?
Okay. Well, it is our in our affidavit, we have tried to justify the same on the ground that well, we have stated in paragraph well, from paragraph 12 onwards. Well, 13 and 14. Now, in all the cases which have been cited by my learned friend, well, I had the occasion to consider, well, mainly those. With regard to RS trading, Delhi High Court, well, more or less all have different facts. One have issued searches on one or the other. In the case of Shabu George, well, money was lying idle in the house of the appellant, and the cash was found in the house. The third one is Kusuma.
No, but the question was whether it is within your power, whether you have power to seize. First of all, that has to be there. If power is there, you have authority to seize, then in that case you can go ahead.
Though I have to say what is there, we have as per the law, we cannot. Until and unless.
So that seizure will be lifted. Yes. I will make provision for that. That will not make the the custody of the cash with the petitioner legal. I'm not going to.
I have to relate. If I go on the larger issue, whether the cash forms part of the fraudulent activity of the ITC, I have to, as per the judgments which have been cited and the judgments which are there, I have to see from the records of the petitioner or the person concerned whether there are any similarity or there are any notings which corroborate the recovery of the cash. So to that extent, we do not have such overwhelming materials to support as of now. As of now, we do not have such materials, though the department supports the same that we have the power, but as a council, we must be fair to your law.
No, cash seizure, there has to be express power in provision. I mean, in the statute. If it is not there, it is not there. I will clarify that lifting of the seizure or the lifting of this custodial seizure, sort of, that it is in their hands, that will not be treated as a pronouncement of the validity of the custody of cash with the petitioner. That will be decided in appropriate proceeding. But the seizure per se is not legal. Therefore, that seizure has to go. This I will observe. And so far as the writ petition on merits is concerned, that has to be heard upon exchange of affidavit.
For your lordship, seizure of money only. With regard to the satisfaction that my learned friend was submitting, that there is no reason to believe there is no approval, we have to put it on affidavit. The note sheet.
That I'll give
note sheets.
And my lord, subject to correction, my lord, that a stock, my lord, this they have seized in the affidavit, my lord, paragraph 15, my lord, paragraph 15. Kindly have a look. They're saying, my lord, that I am not going to secure, my lord, the revenue. It's my duty, my lord. They are saying that approx 5 lakhs. So, my lord, they seized, my lord, but kept in my place in the open yard the Almirah, my lord, because Almirah, my lord, will damaging, my lord, day by day. It will harm. It will, my lord, with bond, my lord, approx 5 lakhs. They are saying tax evasion. As per my calculation, total value is approx 30 lakh. So 30 lakh value is, my lord, tax around 5 lakh. So I am ready to submit the bond and bank guarantee of 5 lakh. So the stock may be released. I can sell the goods and pay the government revenue also, my lord. And my lord, importantly, my lord, in the last financial year, my lord, I have paid 5.5 crore tax So comparing 5.5 crore tax, though I am not admitting, this 5 lakhs reversion not possible. It is a 5.5 crore tax I have paid, my lord.
The suggestion which my learned friend is giving now, let it be made before the authority concerned and let them decide within a period of 3 days or 4
No,
days
my lord, no.
for the purpose of releasing, because whether those stock or whatever is required for the purpose, because he is.
I'll admit the writ petition for the balance portion after the cash part.
Lordship.
And I'll give you liberty, despite exchange of affidavits. I'll not make that mandatory order. I'll give you liberty to approach the authority,
Let them decide.
making a representation that if you can secure this sum of 5 lakhs, which is found to be evaded by you, then in that case, whether goods can be released or not.
And one more request to my
then, my
learned
lord.
friend, let him cooperate with the investigation.
No, I am ready, but my lord,
But he
what
will-
problem? I am not absconding. Learned senior friend, my lord, said last day, my lord. It is not
let him
proper for the
cooperate so that
good
he can
businessman, honest taxpayer, my lord.
whether he is at all involved or not involved. The investigation has to come to a logical conclusion.
My lord, I am
The
telling
time period is
Because it says tax evasion of 5 lakh has been noticed till date.
till date.
That date. After that, also suppose.
No, my lord, I am here, my lord, challenging the entire such proceeding.
Very
my
well.
lord. That is
if
why, my lord,
so, Mr. Rai, sitting here on the basis of this, I cannot pass an order of release right now.
yes, my lord.
Because that has to be taken stock by the authorities only. It's a factual thing. Whether
As my lord, my little understanding, as the stock was not taken, because my lord, entire stock it will.
So that has to be decided in affidavit. How now?
Yes, yes.
direct release?
That is why, my lord, I am praying, my lord, that after completion of the hearing, my lord, after passing of final order, if your lordship think that I will cooperate with the investigation till date, my lord, stay, my lord, and till date interim measure, my lord, I will pay the bond and they release the good after passing of your lordship final
So
order.
that you pray before them. I'll give you liberty.
Then, my lord, they will start the investigation during pendency of the writ petition. That will create problem.
Investigation has to conclude. How can
Because
investigation?
I am challenging entire procedure, my lord, here. Because the independent witness.
It will be lost in due course. He will be creating subsequent documents
no.
and with the apprehension.
No.
I should say investigation will be completed. The final order will not be passed till the date.
Yes. Then must.
Investigation can't be stopped.
Then maybe, madam.
Investigation will go. Final order will.
Final order in the form
will
of
be.
no cause notice will not be given effect.
Yes, final order, even if it is passed, it will not be communicated, not be uploaded on the portal. That's it.
Without the leave.
Then no problem.
Without
But,
leave of court, of course. Without leave of
yes. Then, my lord, there is a practical problem. If, my lord, they after finishing of bond, my lord, if it do not release, my lord, the goods will damage, my lord. It will.
That is why I am saying you make representation before them for them to consider. I will not assess all that that in writ petition. You are making.
And, my lord, one two line observation that independent witness, my submission, independent witness not brought, violation of fiscal.
Those are on affidavit. You
Yes,
have
yes.
stated your case in the writ petition. He will state his case. I will decide. No observation right now. Right now we are only on the cash seizure aspect and exchange of affidavits.
And cash are lying in my drawer with seal.
Yes, that I'll
They
say
will-
that. I will make my observation.
Mal.
Okay. The writ petitioner, Akhil,
23, man. Yes, yes. 23, my lord, there is no seizure of goods, my lord. They are saying that shortage of stock. But in this case,
There is
also,
no seizure of money here.
seizure of money here.
Very well, শুনুন ওই টাকার যে পোরশনটা আছে না
না ওইটাই
solve. Everything is not required to be recorded. They will deal with it.
Yes, my duty, my lord, my.
Report in the past. But here there was no cash seizure.
No, no, no.
Then report, why report was required?
Well, this copy paste.
Copy paste, honestly.
Then the cash has also been copy paste?
No, no.
No, no.
Copy paste except
Report in the form of affidavit filed by the respondent.
all are copy paste. For compliance.
হ্যাঁ প্রথমটা করে আমাকে দিয়ে দেবেন তাহলে আমি করলে ওটা
Hey, বাকি দুটোটা নিয়ে
Hey. 24 and 25, my lord, in the Panchnama, first phase of the record, there is no adverse.
Cash is cash
No,
is here.
no
or
cash here. And
very well, then it's all same.
same, or rest are same. But here, my lord, no allegation against me. I'm free here, but investigation going.
এখানে শুধু এই 25-এ 24-এ একটা অর্ডার রেকর্ড করে নিন
Same as
Oh,
24.
no allegation.
No allegation against me.
Very well. This will be recorded.
Grateful.
I'm
And
grateful.
there is no cash involved in the
No cash involved, no good seizure and evidence.
And the order will be the same. Investigation will continue. Final order will be passed, but not communicated, not uploaded.
Yes, my lord.
Right, Mr. Right, clear.
Yes, clear, my lord. But only I am praying, my lord, that one line video camera, my lord, because
As said in terms
to
of
protect the honest taxpayer, my lord. I'm grateful, my lord.
Yes, Mr. Mullah, yes.
One page written argument, my lord, submission, my lord. But kindly, my lord. The seizure of port consignment of white rice, non-basmati of quantity number so-and-so, value to be so-and-so was made by the DRI Kolkata Zonal Unit by way of the order under section 110 of the Customs Act 1962, dated so-and-so on reasonable belief and ground that the same was liable to confiscation for contravention of the said Customs Act 1962, alleging incorrect labeling and misdeclaration of the country of origin, which following the investigation conducted by the DRI, Kolkata Zonal Unit, culminated in the so-called notice dated so-and-so, issued to the petitioner by the Additional Commissioner of Customs Court, Kolkata, which merely proposed imposition of penalties under section 114 A and 117 of the Customs Act. A written reply to the so-called notice was submitted by the petitioner before the concerned Additional Commissioner of Customs Court on 12/8/2025, rebutting the allegations brought against him. In the said written reply to the so-called notice, it was categorically requested to release the seized goods, that is the consignment of white rice, non-basmati, since the customs authority did not intend to confiscate the seized goods at all, citing adequate reasons mentioned in the said so-called notice dated so-and-so. the consignment of white rice non-basmati, which contains one number of packages, 1 kilogram each being edible items, have limited shelf time, are prone to decay easily and likely to get infested with worms and insects due to prolonged storage in the improper and unfavorable storage conditions, rendering same as units for human consumption eventually may be substantial financial loss to the. So at this juncture, considering the perishable nature of the seized goods, for which the customs authority did not even propose for confiscation under the provision of Customs Act in the so notice, the petitioner urges unconditional release of the seized goods.
Or I will cut it short. I will tell you what is that. They were making exports, declaring that the products are of India, and the declaration was made for the reason of two. One is regarding the GST for the goods, other was regarding the country of origin. What they have declared under Section 15, country of origin is India. In actually, those products are of produce of Bangladesh, which they have mistaken. Therefore,
Not product, labeling, only labeling. Bosta, my lord, Bosta global.
We have to refer to 2 pages and that will make the picture absolutely clear. Now, my lord, the goods were seized. They made an application for provisional release of the goods. Provisional release application was configured, order was passed. They choose not to accept the order of provisional release. If on record, they have declined that. In the meantime, show cause notice has been issued. They have filed reply. Proceeding is going on. Well, this is the matter. Now, Lordship kindly comes to page 40 and 41. This is the Panchnama. Panchnama is the proceeding by which the goods have been seized. Now, Lordship kindly comes to page 41. What has happened is, they have imported those goods in small bags of 1 kg. Though in those bags, it was clearly imprinted as product of Bangladesh with company name and everything. Now, those 1 kg bags were put into big sacks of 26 kgs each. There were around 256, there were around 962 such big 26 kg bags. Now, we cut open some of the bags and took random samples. Now, Lordship kindly sees the samples. Lordship kindly comes to page 41.
41.
Yes, 41. This is the Panchnama proceeding. Panchnama proceeding is done and conducted in presence of 2 independent witnesses and in presence of their own representative also. Now, Lordship kindly comes to page 41.
Yes.
Lordship kindly sees the first line. Upon initial examination of these 1 kg packages, it was observed that the front side of each package was labeled with Mezwan Chingnigoda Sogondi Chal in Bangla, which the reverse side displayed Chingnigoda aromatic rice, along with manufacturing date, based before date, batch number, MRP. However, no MRP was found printed on those packages. It was further noticed that each package had a sticker labeled product of India. Upon removing these stickers, the original label underneath read product of Bangladesh. So this establishes that the core product, the basic product which they were trying to export out of India, were produced of Bangladesh, whereas under the shipping bills, they have declared those to be produced of India. And as per Section 50, they have to come up with truthful declaration, which they have not done. Therefore, the declaration they have declared under Section 50 is incorrect. And they have not made any objections so far this Panchnama proceeding is concerned. They have not disputed this Panchnama proceeding. And they have already participated in the proceedings. Let them participate. Let the show cause notice proceeding come to its logical end.
My lord, no proposal for confiscation was there.
If there is no proposal for confiscation,
no confiscation,
still you can detain the goods.
I did not want the reason. The reason is that they were allowed to get the release of the said goods, which they have declined to take it under provisional release.
My lord, huge amount.
Once the goods have been seized,
was claimed, my lord. Huge amount was claimed.
Just take me to the provision.
My lord, only one thing on there is a matter at 2 p.m. before Justice Kaushik Chandikar.
Huge amount was claimed, my lord.
230.
My lord?
230.
My lord.
Because he has, he said that he is another matter. I'll pass it over at 2.
My lord.
Yes, Mr. Rai.
That the for liberty may be given to approach the authority for release of the goods, my lord, in accordance with that.
I'll give that.
My lord,
Now ask Mr. Banerjee to be
Yes,
here
I
at
will
2 p.m. Ask him.
2 p.m. Oh, yes.
I'll
Yes.
I'm sorry. My lord, I am told that Mr. Chandra takes some time to, my lord, start the second half. So we'll come to your lordship. If it is any difficulty, my lord, we might pray for it
Then what will happen?
No proposal, nothing, my lord. I will face the consequence, my lord. If the
We'll be here at 2 p.m.
Release.
But if 2 p.m. we are not able to take up, then what will happen? Then
That's if your lordship can take it up tomorrow, my lord.
tomorrow we'll be having those public permission unauthorized occupants act matters. Friday will be specially assigned.
Because I'm told by Mr. Honji another 2 p.m. matter speaks before the honorable 7:59.
My lord.
Then three, if your lordship allows us to come.
We will be original size.
Well, 2:45, my lord. It's possible.
Then can we have it on Monday then?
Monday.
Oh.
I'll refer to the लिखे नहीं order reference. Hard Mr. Molda. Ask him to come, Mr. At 2 p.m. I'll
My lord, my learned friend is there, Mr. Banerjee is coming.
Yes, I will incorporate that he'll be entitled to make representation that upon payment of rupees 5 lakh, the stock may be released.
My lord, that instruction has to be taken up because
He'll make a representation before the authority. What instruction he will take? He will make that representation. You consider it, reject it, whatever you feel like. Representation also for that, whether he'll make a representation or not, for that he'll need instruction.
Yes.
That was what I was saying.
Yes. And release of cash, my lord, within 2 or 3 days, my lord, because otherwise they will be late, my lord.
Yes.
Only that, my lord. I'm there.
I'll not frame any time frame. They will dispose of the representation expeditiously.
No,
because-
not my lord. Deseal the cash, my lord.
Yes, cash.
Within 2 or 3 days, my lord. Otherwise, my lord.
I'll say immediately.
Yes, yes.
I have already verbally completed.
Very good.
I'm grateful.
Thanks.
Lordship, may I mention serial 450 for that cash reason?
450.
Lordship, that was same cash reason I mentioned in the morning. So, Lordship, may I mention tomorrow physically again once this order
Very
is there?
Very good.
Grateful.
450 টা উপরে urgent দিয়ে দেবেন।
It is only cash season, no, nothing more challenge, Lordship, only cash. Thank you. Grateful, dear Lords.
My lord, the order under contempt is at page number.
Page number?
My lord, one second. Contempt application.
15.
Yes, my lord. Yes, my lord. The order under contempt is at page number 15, my lord. Now, my lord, may kindly come to page number 16, which is the operative portion.
Reconstruction of the record.
Reconstruction of the record and delivery of those records, my lord. Now, my lord, I have been provided after filing of this contempt application. No, this is the original copy. This is what I have been provided. So, my lord, no record that has been reconstructed.
Very well. You have a copy. Please listen. This is an application alleging contempt of an order dated March 28, 2025.
And I am for the applicant, my lord.
Yes.
My lord, order passed on 1st July 2025, my lord, with the direction within 4 weeks, hearing the petitioner, my lord.
Same order করে দিন এই শুধু alleging contempt of an order dated March 28, 2025, passed in WPCM date 27591 of 2024. একই দিলেন নাকি? কি দিচ্ছেন দিদি? একই ম্যাটার আবার দিয়ে দিলেন?
My lord, one mistake, my lord.
দিচ্ছেন। ও বারবার ভুল করছেন কেন? একই জিনিস বারবার দিচ্ছেন। Alleging contempt of an order dated. Where is the order, sir?
My lord, order dated last, my lord. Last page of my
July 14, 2025, passed in WPA 14464 of 2025. Sorry, sir.
My lord, one mistake, my lord.
What mistake?
My lord, 472 item, my lord, can number CPN 1472 against my lord WPA number 111075, my lord. There is a mistake on my behalf, my lord.
Fine.
There is two contempt, my lord. One is 14464 and one is 111075. Can number 1472 against my lord 11075.
And 1472.
1472 against WPA 11075. But wrongly appeared in the 1446, my lord. 14464.
Both the orders are annexed in this.
No, my lord. Separate petition, my lord, separate order has been annexed.
Order has rightly been annexed.
Rightly, my lord. Order has
What is the problem? That it's appearing as 1472 CPAN 1472 is appearing in 11075.
07.
It's appearing with that. There is no mistake. What is the problem?
But full day 1105075
Yes.
instead of the 14464, my lord. My lord.
এখানে অর্ডারটা অ্যানেক্স করেছে ইয়েরই 1073. Which one? You have annexed the same order.
My lord, order is annexed rightly, my lord. But accept the list. List is wrong.
List
my lord.
is also rightly showing. What is the problem?
List is, my lord. CPN 1472 against, my lord,
ঠিক আছে
WPA.
আপনি ওই ক্যানটা ঠিক করে লিখে দিন।
Right, madam. Gratefully.
ঠিক আছে এই দুটোতেই সেম অর্ডার। অর্ডারগুলো দেখে ডেটটা ঠিক করে নেবেন যারা। নেক্সট
My lord, next date, my lord.
8 January.
8 January. Gratefully, lord. Serve upon the contemner, madam.
Yes, yes. Serve upon the contender intimated. A file affidavit of service on the return date. If any none appears for the petitioner, no accommodation is. Same order for dismissal on January 8th.
This is my application, your lordship. Your lordship ordered 9/6/2025 side.
This
I have
is
configured the page. Page 20, your lordship. the order.
Page 20.
20.
Yes. what
Ordering
is
portion
happening?
at page 24. Last paragraph 24.
That was same. January 8th.
Get to.
Sir, file affidavit of service.
My lord, may I please your lordship? My lord, may I please your lordship? Well, I am not visible, my lord.
You are not visible.
My lord, no link. My lord, I am not visible, my lord. My lord, my
same
my,
order
meet-
My lord,
my virtual mode has been muted, my lord.
I'm for the petitioner. My senior is on the virtual mode. We comply in this method. Last order dated 8 August 2025, page 13. We have complied this communication dated 13th August 2025.
Serve this petition upon the alleged contender. It
Yes.
will appear again on 8th of January. File your affidavit of course.
We serve this on hand. Kindly fix next week.
8 January, same order. Next.
হ্যাঁ হ্যাঁ
I beg to appear on the petition number. Now, there is a violation of your lordship order dated 19th June 2025. Your lordship was directed to consider the representation. Thereafter, it
Not
has been
done.
not done. The communication has been given, contempt notice has been served, but till date, no step.
Sir, this contempt application, same order করে দিই।
Now that these 478, 479,
Yes.
480,
Yes.
482 are same.
478, 79, 80 and 82.
Are same. Only the 480, the order date of the Honorable Court is 18/6/2025.
Which one? 480.
480.
Order date টা দেখে নেবেন তাহলে। 478, 79, 80, 81, 82. All.
Now, 81 will not separate.
81 you are not appearing.
I'm appearing, but separate matter order, separate matter.
Very well, that we will see.
Sir, only one thing, because why I'm submitting. Only 481. After your lordship passes the order. Your lordship, can you remember this is a matter when I said that the petitioner got the permit by virtue of the order of the other in auto matter. Thereafter, your lordship passed an order, they have not given opportunity of hearing. They issued notice or in the notice, they have written 13. They posted the notice on 18, given hearing on 28. My client could not appear because on 28th, my client did not in the home. But his elder brother received the notice. Thereafter, your lordship ex parte order has been passed. But only I am getting the fact before your lordship because the respondent may come and say this fact have not been placed before your lordship. But he is required to be served upon the contempt because your lordship direction was they consider the representation of the petitioner whether there is obstruction by the private respondent. In the ex parte order, no consideration has been made.
Very
Deeply obliged.
Then it will be on merit. Contempt may not be there.
No, yes, I will satisfy your lordship because the representation maybe if I say the notice is given me and I could not appear. Even I for the sake of argument say notice I have received, I could not have. But your lordship direction was they will consider of my representation. There is no single line of consideration of my representation.
Very good. We'll see, let them come.
Deeply obliged. Well, only one thing, in item number 481, new incumbent has come.
Or you want to change the name then?
Then I want to incorporate the new incumbent.
481 একটা order record করে নিন। 481 এই contempt ওই লাইনটা থাকবে তারপরে Mr. Bhattacharya learned advocate appearing for the petitioner submit that a new incumbent ইয়েটা দিন তো file দিন। Who is the
Srimati Mukta, the district magistrate, he transferred the new man, Footstreet Ali. I will incorporate, you have to kindly leave.
That the district magistrate he seeks leave to incorporate the name of the present incumbent upon deleting the name of the earlier incumbent. Because this is not required. Full stop, such leave is granted. Let cause title of the contempt application be amended accordingly and a copy of the contempt application be
$82 is same code and same.
Yes, next.
My lord, this is my application, where, my lord, I will draw your attention to the fact that subsequent events which have taken place during the pendency of the writ petition, my lord, I have served and I have served repeatedly. My lord, I have served every time I have come and mentioned before your lordship for an upgradation also. My lord, they choose not to appear. My lord, essentially, I'm not praying for any relief against them. I'm praying for disposal of the writ petition. My lord, may I just hand over the last notice that I have served, my lord, after your lordship had been pleased to even allow my mention.
What is your matter? You tell me that first.
Yes.
What do you want?
My lord, I am praying for disposal of the writ petition in terms. My lord, may I indicate, hand over the mentioning notice also, my lord. Notice that I had given that your lordship had been pleased to upgrade the matter actually.
Disposal of the petition,
Yes.
what order? By passing which order?
My lord, may I first take your lordship to straight away to the closure notice that has been issued in my favor. Just briefly the backgrounds, my lord. My lord, I am an approved vendor of the railway. My lord, I manufacture certain parts which are used by the railways, my lord. My lord, I work in tandem with collaboration with an original equipment manufacturer, which is a foreign entity. Now, my lord, I was an approved vendor in terms of the railways policy. My lord, subsequently, there has been a change in the policy. And on the basis of that policy, my lord, certain documents were initially asked from me. My lord, when I submitted the same, upon consideration of that, my lord, a show cause notice was issued, saying that you do not conform to the requirements of the policy. On the basis of that, my lord, a temporary delisting order was also passed. My lord, I rushed to this court, challenging both, my lord, the temporary delisting order and the show cause notice. At the interim stage, my lord, this honorable court was pleased to stay the effect of the temporary delisting notice. Now, my lord, in the meantime, what happened, my lord, the Vigilance Board of the RDSO, my lord, they initiated an investigation, passed a final delisting order. My lord, I took a challenge to that before the Delhi High Court. Delhi High Court quashed it and said, no, you did not give them a chance to represent their case. So therefore, I'm giving you a chance to issue a fresh show cause notice. A fresh show cause notice was also issued on the same subject matter to me. I again submitted documents. My lord, several years have passed, 4 years have passed in the meantime. I followed it up. My lord, now, my lord, in October, a letter has been issued by RDSO saying that we've gone through all your documents and referred to also the show cause notices and says very well, we are closing the subject matter of the dispute. And at the same time, we are reserving our right to approach any other forum with regard to any other matter. So by specifying any other matter, my lord, I read this closure notice as a closure of all the grievances they have against me. So my lord, on the basis of this, my lord, my writ petition itself, my lord.
Where is that notice?
My lord, that letter is at page 131. Sam Ganguly. Sam Ganguly appears. Cover. Your lordship will find, my lord, towards the bottom. It says closure of the show cause notice. My lord, this is the notice that was issued to me, 29th of December, 2021. To me, and Thales is my original equipment manufacturer. My lord, it's a German entity. And your lordship will find that it says that this closure will not confer any right or claim whatsoever on the firm against the department, doesn't affect rights of the department in any other matter, and shall not give the order.
None appears for the respondent. Can a league order? Can. And one of can 8 of 2025. Learned advocate appearing for the petitioner invites the attention of this court to a. What is the date of this letter?
Lordship, Mr. Ganguly will be appearing for this matter. He is in some personal difficulty for Union of India, Lordship. Paying for not today. But if any other date is being.
My lord, may I object to it? My lord, my petition, my lord, I am.
Somebody in personal difficulty, you should not object. And recording an order to a letter dated October 8, 2025. Who is the issuing authority?
My lord, RDSO. Your lordship will find, my lord, on top, my lord, right at the top, my lord, in the middle, Government of India, Ministry of Railways, Research Designs and Standards Organization. RDSO.
On behalf of the Research, Designs and Standard Organization, comma, Ministry of Railways, comma, Government of India, whereby the petitioner has been intimated that upon scrutiny of the replies furnished by the petitioner to a show cause notice dated December 29, 2021, issued to the petitioner. Petitioner or petitioners?
Petitioner.
Both these companies are petitioners.
No, my lord, the company is a petitioner and a director is petitioner.
There is another company also in
Yes, my lord,
same-
that is a German entity.
So that is not involved. To the petitioners for delisting of their, within inverted comma, MSDAC and SSDAC, comma, the competent authority of the said organization, comma, has approved closure of the said show cause notice dated December 29, 2021, issued to the petitioner. Full stop. Paragraph. Learned advocate appearing for the petitioner submits that in view of such communication, comma, the writ petition and what was the prayer?
My prayer was disposal of the writ petition.
No, what was the prayer in the writ petition?
My lord, prayer was, my lord, I was challenging the, show cause notice and the
writ petition. Then the writ petition has become infructuous sort of.
basically, my lord, all that I was praying for, just a recording of this order, the subsequent development, my lord, this will help me in getting further orders from them, my lord. Basically, our only
So,
buyer
madam,
is
when do I keep it?
Not today. Any cash flow.
my lord, well, it is not as if Mr. Ganguly will be here, my lord.
If I
he will
was to
be-
record only infructuous, I would have recorded that it had gone. You want some further recording, then in that case it could be there. Infructuous I can record right now.
No, my lord. Infructuous is not what I want. my lord.
That is why he's required to be here.
Well, my lord.
Yes,
my lord, tomorrow.
Tomorrow I'll be having different determination because
Oh, yes,
every
my
day
lord.
I cannot take the same thing. The writ petition stands answered in favor of the petitioner. Full stop. Ms. Onar naam to likhne mein. Ms. Kachinsat appears and submits that Mr. Ganguly, appearing for the respondent, has not come to court due to personal reasons. Full stop. She seeks an accommodation on his behalf. Full stop. In view thereof, list this matter once again on. सामने बुधवार दिए देवे ना बस.
My lord, some preference may be given. my
Wednesday
lord.
again same time application will be called.
Very. My lord, may I file my affidavit of service, my lord? if you
Affidavit
can?
of service shall to be taken under this. Madam, you know what instructions you have to take. There was a show cause notice challenging and a proposed delisting or an order of delisting also.
I'm sorry, my lord.
There was an order of delisting or a proposed delisting.
No, my lord, there was an order of delisting, temporary.
There was an order of temporary delisting and a show cause notice challenging both of them. This writ petition was filed during pendency of the writ petition. Their replies have been considered and the competent authority has said that we are closing the show cause issued to them. If the show cause is closed, then in that case the delisting, which was a follow-up of the show cause, will also go. And that is the order that she wants the court to record. Take instruction.
My lord, may I take back the notice of?
ये टेक अप एक फिर दी सामने बुद्ध
I'm so grateful.
Next.
Well, I am for the petitioner. Well, matter is very short. Well, there is a very pandemonious situation in the school. Well, in the school.
What is this application for?
Application for appropriate order for the early disposal of the writ application.
Affidavits are complete.
Affidavit
have my affidavit in.
And what is the writ petition for?
Writ petition only. Well, writ petition only. I am seeking that.
For implementation of the board order.
Yes, by the commissioner of the school education. It is my prayer in the writ petition. Already affidavit direction was there.
And where is the reply?
Well, I have filed the reply, Malad. Here and now.
No, Mr. Isa Gupta.
Well, just now it was handed over report on behalf of the state.
Affidavit in opposition filed on behalf of the respondent.
I was just wondering what I should say.
I'm a DD.
अच्छा एफिडेविट तो कंप्लीट है अंडर द हेडिंग हियरिंग
Subject will also talk much.
We'll see. There are so many other hearing matters. Let us see. Yes.
Well, the application is still pending.
Pending. All are pending. They are not here. How can I disclose it? Under the heading hearing. Yes. Next. Yes.
Well, it must be an application for modification of these order dated 3rd September 2025.
I will not be able to modify the orders. Liken it.
Well, the next matter is also same one.
It will have the same fate. This is an application for modification of an order dated 3rd September 3, 2025, passed by the naam लिख लेंगे. This court does not have determination to take up such application, full stop, in such view of the matter. What the prayer is, because it will be difficult.
He has written modification.
Difficult. Unnecessarily, why will I invite trouble?
But that's why I said 152 of PPC. This is an application, is not make an extension of it.
Modification you should not. After the garden breach judgment, you should not. It will be without jurisdiction.
Absolutely. When I read the commercial code, that's what
$27 क्यों नहीं? What to do? Not today করো না. ভাই হয়তো ভেবেছে অনেকক্ষণ চলবে বলে আসে. চলো. Mr. Banerjee, in that matter, Mr. Rai informed you about.
Yes.
I'll incorporate that.
I appear for the petition,
Yes.
Your Lordship. We've challenged appellate order in GST, Your Lordship, that has been rejected on the grounds of delay. There is a delay of 43 days in filing the appeal.
Yes, Mr. Kapoor, for 3 days you are not.
It is attributable to the health issues faced by my authorized signatory
Very.
tax consultant, and I've
that was not good. I am not going into that. But
I've annexed all of the documents, Your Lordship. We filed for it.
We'll try to maintain it. The order shall not remain effective. I'm stopping at that. If he's satisfied, if he's satisfied with the delay, the order will not remain effective. And if he's not satisfied, consequences will follow. Yes. Now Mr. Chakraborty is not there. He was there on last two occasions. Everybody thought that those applications and contempts will go on. What to do? Likhe and his presence will be marked. None appears for the petitioner.
If serial 30, I beg to appear virtually.
Yes.
I apologize, Lordship. I had to come. As what Lordship was saying, I also thought that it will continue. That is why I came back to the chamber. Lordship, this is a matter, wherein, Lordships, I am challenging a rejection of a amnesty scheme which was introduced under GST. Lordship, section 128A was introduced by the central government for the purpose of giving relief of interest and penalty if entire tax is paid for financial year 17-18, 18-19 and 19-20. That is under 128A, Lordships, and the relevant rule is 164.
Yes.
In my case, Lordships, before there was a departmental proceeding and I was issued a show cause notice on 27th of December 2023 for 2 financial years, which is 18-19 and 20-21, which is at page 37.
37, yes.
37, Lordship, this is the show cause notice, wherein there are 2 financial years, Lordships. Kindly takes, Lordships, the period Lordships will get at the first paragraph. First paragraph, second last line, for the financial year 18-19 and 20-21.
Yes.
So, Lordship, out of the total demand was 2.46 crores. Now, Lordship, kindly takes the last page of the show cause, which is at page 42. Page 42, Lordships, out of 2.4246, I had already paid 2.30 crores, which was appropriated in the show cause itself. Lordship, page 42, serial number 4.
Serial number 4.
Lordships, that amount of 2.30 crores already paid by the RTP should not be appropriated. So, Lordship, this was the show cause. I furnished, there was an adjudication order at page 55, Lordships. DRC 07, Lordships. Detailed order starts at page 57.
Page 55, yes.
55 is the summary, Lordship. 57 is the detailed order. In the detailed order, Lordships, the kindly take, Lordship, the last page of the detailed order, which is at page number 73. The entire tax was confirmed and the amount already paid was appropriated. Page 73, Lordships.
Yes.
I disallow the input tax credit of 2.46 crores or only wrongly availed and utilized an order for recovery of the said amount of ITC from SS this, read with corresponding this. I also order for appropriation of ITC of 2.30 crores. That means, Lordship, my net demand was left to be around 16 lakhs. And Lordship, I was imposed an interest under clause B and 10% penalty under clause C because it was a case under 73, not 74. Now, Lordships, before the amnesty was introduced, I filed a statutory appeal against this order under 107 because amnesty was not introduced by them. That is at, Lordship, page 75, my APL 01. In the meantime, Lordships, this was filed on 28th of June 2024. Lordships will take the date at page 77, left hand side. Page 77, the date of filing is there, 28th of June 2024.
Yes.
So I filed the appeal against this order so that for the amount which was left to be paid. Now, in the meantime, Lordship, the amnesty scheme came into picture. 128A was introduced, wherein I was given a benefit if I have paid the entire tax. Then I will not be liable to pay any interest and penalty if the matter is under 73. My case, I have shown your Lordship, it is under 73. 1819 and 2021, 2 periods were there. So therefore, Lordship, the board came up with a circular कि in case you have filed an appeal before the appellate authority which has periods under amnesty and without amnesty, you have to write an email to the appellate authority stating that you want to withdraw the case for the period covered under amnesty, and the next period you can fight. Accordingly, Lordship, based on that instruction at page 109, we wrote an email to the appellate authority giving reference to the board circular, they stating that we don't want to pursue the matter for 1819. And simultaneously, we applied for amnesty scheme at page 104 for 1819. Then, Lordship, the department is for the amnesty scheme, the department issued me a show cause notice for certain further details at page 120. I replied to that, and page 125 I submit my reply because there was 4 lakh rupees short tax paid, which I had to pay, which I have paid with my application. Now, Lordship, what happens in the meantime? My appellate authority, without taking cognizance of my email, disposes of my appeal by confirming the entire amount. And he remarks in the order that I am not eligible for amnesty, which he could not have done because amnesty was not under his purview at all. I filed a rectification for that, which is still pending before the appellate authority. And my proper officer who was dealing with the case of amnesty, he rejected my amnesty application on the ground that I have not furnished a reply. And in the summary order, he records my date of reply. But in the detail order, he writes, you have not furnished any reply, therefore I reject.
Yes, Mr. Banerjee.
Plus, Lordship, personal hearing. We sought personal hearing, we sought an adjournment. He writes that you did not appear, you never appeared. And Lordships, the critical point, the detailed order is passed by Assistant Commissioner Mr. A. And the summary order of the rejection is uploaded by Assistant Commissioner Mr. B. They are 2 different officers of the same division. Assistant Commissioner of a division can be one only. The person who had passed the detailed order stating that I have not filed a reply, and the person who has digitally signed the summary order, who records my reply in the summary order, the date of reply, are 2 different persons. So, Lordship, I am before your Lords on 2 grounds. One, that the appellate authority could not have commented on the eligibility of amnesty because that was outside his purview. He was bound by the board circular to allow me to withdraw that appeal for the purpose of 1819. And the proper officer who was dealing with the amnesty scheme, giving the date of reply, taking the date of reply on record, writes in the detailed order that I have not furnished the reply. So, if the amnesty rejection order has to go, it has to be remanded back to the proper officer to consider my reply, and he will call me for a personal hearing. And appellate authority's order also has to go, Lordship, to the extent it is for 1819.
Yes, Mr. Banerjee.
Well, 2 multiple things are different. One is the rejection of.
One is the assumption of jurisdiction by the appellate authority in commenting upon the merits of the amnesty application. Second is non-application of mine by the proper officer under the amnesty scheme dealing with the petitioner's application. He says we have not filed reply. Therefore, he has proceeded on the basis of there being no reply, and there is a reply. And in the earlier portion, he says he has noted that. Where is that order, Mr.
Lordships, the rejection order?
Yes.
Lordship, page 135 Lordships may take the summary rejection order wherein my date of reply has been recorded. Page 135, the table is there, Lordships.
Yes. Reply
to show cause date 20th of July 25.
Yes.
Now, Lordships, kindly takes the detailed order starting at page, and Lordships, Who has page 136? Kindly takes the officer name. Mr. Sujoy Bhowal, Assistant Commissioner. He has uploaded the summary order. Page 136.
Yes.
Now, Lordship, page 137 is the detailed order. First line, passed by Sri Jugal Krishnapal. Another officer has passed the detailed order. Now, what he writes, Lordship, kindly takes page 139. Para number 2.2. 2.1 personal hearing, 2.2 taxpayers return reply. The taxpayer did not file any submit any reply. He writes in bold. He uses bold font to satisfy your lordship that he has not filed a reply.
Personal hearing was granted.
Personal hearing was granted. I took an adjournment and I sought for another date. He does not record that also. Lordship, he does
But
not.
he says there was no request for adjournment.
Lordship, the document is on record.
Page?
In my show cause reply only I had sought a personal hearing because it was the same day. Lordship, kindly take taxpayer's written reply to SPL 03. The taxpayer did not submit any written reply. Page 139, Lordships, in the para 2.2.
Yes.
2.2.
Yes.
The taxpayer did not submit any written reply to the SPL 3 issued to them. The taxpayer did not submit any reply through the portal either. In fact, taxpayer did not submit any reply in any form whatsoever. Now, Lordship, kindly takes my reply, which is on record. Page 120. 120 is the show cause. Page 125 is my reply. Detailed reply. 125 is the reply, Lordships. Annexure P9.
Page 125.
125 is the, yes, Lordship. Page 125 is my reply.
Yes.
Lordship, SPL for reply to notice, the heading. Date is there, Lordships, 20th of July.
Yes.
And the detailed reply starts at 127 onwards. And 128, I had prepared a table to show that all my tax for 18-19 has been paid. Lordship, out of 2.46 crores, 2.30 was paid already. Your Lordship has seen that. For 18-19, the total demand was 2.34 crores. So I had to pay 4 lakh more. That 4 lakh also I had paid.
Yes.
And in the order rejecting, he writes that you have not furnished any reply. And in the summary order, he takes this date. Lordship, again, Lordship kindly takes 135. In the table, he writes the date of show cause reply. Page 135, reply to show cause dated 20th July. Page 135, Lordship, table, third line.
Very well. Yes, Mr. Banerjee. And where is the appellate order?
Lordships, appellate order. Lordship, kindly take the appeal order at page 144, the summary order. Lordship, because the bulk of the demand relates to 18-19 and I am entitled to this relief. Therefore, Lordships, we had applied because for the 2021, the demand is only 12 lakhs, which we are fighting. Lordship, page 144, the appeal or summary order, Lordships. The finding of the appellate authority order, which is against me, which is not correct, Lordships. The discussion starts at 157. Discussion and finding starts at 157, Lordships. Regarding amnesty, Lordships, the discussion starts at para 9.4 onwards at page 159. Internal para 9.4, page 159, Lordships. I find that the appellant contended that they had paid the amount of ineligible ITC of rupees this before issuance of show cause, thus they are not required to pay interest on the amount of reversal of ITC in pursuance of the recommendation of the council, where the council recommended waiver of interest and penalty for demand notices issued under 73. 9.5, on perusal of the grounds of appeal, I find as per decision taken in 53rd council meeting, section 128A was inserted. Now he goes under 128A without his jurisdiction. He assumes his jurisdiction. In fact, Lordship, the rejection order under SPL 7 is an appealable order. The order rejecting my application for SOD is an appealable order under 107. So on the merits, he could not have discussed SOD. Because I had only, and Lordship, the board circular, which will clarify everything, that the proper of this, the appellate authority was bound. Lordship, may kindly take the board circular, page 101. Exactly the same case the board has clarified. Page 101, Lordships, circular dated 27th of March. Lordships, various issues relating to availment of benefit under section 128A. Lordship, I will take your Lordships directly to issue number 2 at page 103, which is the issue at hand. Page 103, Lordship, para 4.2. Page 103, my lords, are there?
Yes.
Lordship,
Page
4.2. 103, Lordships.
Yes.
4.2, issue 2, whether the entire amount of tax demanded is required to be discharged and the appeal is required to be withdrawn for the entire period where notices, orders issued to taxpayer pertains to period covered partially under 128 and partially outside, which is my case before your lords. 1819 is covered, 2021 is not covered. The clarification issued by the board: in cases where the notice, statement or order pertains to the period partially covered under 128A and partially beyond the period, Rule 164(4) and provision to Rule 164(7) have been amended to allow taxpayer to file an application in form SPL 1 or 2, as the case may be, after making payment of the tax liability for the periods covered under 128A. The taxpayer, after filing SPL 1 or 2, as the case may be, shall intimate the appellate authority or tribunal his intent to avail the benefit of 128A and that he does not intend to pursue the appeal for the period covered under the said section, that is financial year 17-18 to 19-20. The appellate authority or the tribunal, as the case may, shall, after taking note of the said request, pass such order for the period other than that mentioned in the said subsection as it thinks just and proper. Means he was bound to allow me to withdraw for 18-19 and pass the order only for 2021. And Lordship, my email requesting this. My email requesting this is a Lordship, page 109. I give reference to the board circular. I attach the board circular. Page 1110, I make a table for him. You see, this was my demand. This is the extra which I have paid. Therefore, I request you to kindly allow me to withdraw. Lordship, total violation of board circular, total violation of natural justice by the proper officer, and total violation of board circular by the appellate authority. And my rectification is still pending before the appellate authority. He's sitting tight over it. I filed the rectification in July 25. More than 4 months he sits tight. The law prescribes 3 months to dispose of my rectification.
Where is your rectification application?
Lordship, page 162. Annexure P12. The detailed application is at 163. 162 is the portal acknowledgement, Lordships. 163, 164, 165 is the detailed application.
Very well. It's original price time, so I'll dictate orders tomorrow. Mr. Banerjee, what is your
Lordship may pass appropriate orders because there has been some.
Mr. Kanodia, I'm keeping it tomorrow as per orders.
Lordship.
Already 3-5.
Lordship. I will not interject in original side. Taylors.
Hard, Mr. Kanodia, learned advocate appearing for the petitioner, and Mr. Banerjee, learned advocate appearing for the respondent. List this matter as for orders tomorrow.
Grateful, dear Lords. Much of. I apologize for appearing virtually.
Lordship, if I may, items 29 October is leading in that matter. When is kindly mark my relationship. Because it has gone down and none appears.
এর আগের ম্যাটারটা বোধহয় না
Item 29.
item 29 none appears for the petition. How escape solicited Mr. Chakravarti appears for the petitioner and Mr. Banerjee appears for the respondent. Heard Mr. Chakravarti appearing for the petitioner and Mr. Banerjee, learned advocate, appearing for the respondent. This matter 70.
I'm grateful.
Lordship, I have entered appearance in the names in the chat box.
Yes, yes.
Grateful.
যদি ওনাদের নামগুলো রেকর্ড করে নেবেন এই ম্যাটারটা ফর অর্ডার যেটা not today means Monday. Tomorrow we'll be having those public premises may not be called. And if it is called, ask for time. Somebody will pray for time tomorrow and
I'm in item number 23, not likely to reach today. I'm just need some interim relief in this. If it is at all possible for my lord to take up this matter sometime today, I'll need about 5 or 10 minutes only to pray for interim relief.
who's your other side? Who's your other side?
I'll just tell him. That's why I've not even had a chance to speak to him. That's why I'm requesting if it can
If
be
he's ready, then definitely we'll hear it.
grateful.
Extension of the interim order, we should do month of December.
দিয়ে জ্ঞাতি গুলো দিয়ে দিন আর ঝামেলা হয়ে যাবে কাল থেকেই দিতে আরম্ভ করবেন কিছু করে দিয়ে দিন সঙ্গে সব দেবেন না হ্যাঁ কালকে কিছু দিয়ে দিন পরশু দিন কিছু দিয়ে দিন এরকম ইয়েস চলুন কল করুন একটা অর্ডার রেকর্ড করে নিন none appears for the petitioner to fetch Mr. Sharma, none the advocate. Oh. That matter.
Your Lordship, yesterday your Lordship had asked me why I have not participated in the pre-consultation. Your Lordship, today I have a better answer, Your Lordship. Your Lordship would kindly take page 178 volume, please, Your Lordship.
178.
Your Lordship.
Yes.
Your Lordship, this is a show cause notice under section 124 of the Customs Act, Your Lordship. So, Your Lordship, the pre-consultation, Your Lordship, provision is, Your Lordship, is in pre-notice consultation regulation. It applies only to proceeding under section 28 and not in respect of proceeding under section 124, Your Lordship. May I just hand over Your Lordship, it is there in the Customs Act also, but I've just handed, Your Lordship, it may be a mark. And your lordship, I will also place the section. So your lordship, there is no scope for any pre-notice consultation and in a proceeding under section 124. So this notice itself was non-S, your lordship. That notice, your lordship, is it is previous page. Your lordship will find the last two lines. This at page 177, your lordship. This is issued with the approval of competent authority and may be considered as pre-notice consultation letter. So your lordship, this notice itself is non-S.
Page?
Your lordship, notice starts at page 178. 178 is the show cause notice. The pre-consultation notice is at page 175. Last two lines at page 177. They are saying that this is issued with the approval of the competent authority and may be considered as a pre-notice consultation letter. So your lordship, this could not have been issued. This was non-S.
Why?
Because your lordship, as I pointed out, this proceeding is under next page. Your lordship, the show cause is under page 120, under section 124. And section 124 does not contemplate pre-notice consultation. And this regulation is also
Pre-notice consultation is only in respect of notices in the section
under
28.
section 28. And your lordship, here they cannot even amend the notice because your lordship, section 28 can be invoked only within 5 years. Here, your lordship, they sat tight over a period of more than 5 years, your lordship. So your lordship, they could not have initiated a proceeding under 28. They have invoked 124. And your lordship, in 124, there is no pre-show cause. And now, your lordship, I'll trace from the section, your lordship. Section 28, your lordship. Proviso to subsection 1A, your lordship.
Section 28.
28. Your lordship, subsection 1. Then your lordship, A, proviso, your lordship. Provided that, has your lordship found that, your lordship?
Yes, provided that.
Provided that before issuing notice, the proper officer shall hold pre-notice consultation with the person chargeable with duty or interest in such manner as may be prescribed. And your lordship, the manner is prescribed under the regulation. And your lordship, in subsection 1, your lordship, there's a limitation period of 2 years.
And what is 124?
124 is, your lordship, for penalty.
Before confiscation.
Yes, yes. Confiscation, here there was no confiscation. However, they have issued a notice under 124. This provision does not contemplate any pre-notice consultation.
And why do you say that this notice is without jurisdiction?
Because your lordship, the show cause is issued show cause at page 178 is issued under section 124, and 124 does not contemplate pre-consultation. So the pre-consultation goes, it is non-S. Now your lordship would take page 149, 189, sorry, your lordship, page 189.
189.
Point number E, your lordship.
Yes.
The importer failed to comply with the provision made under para 4.42 of the Handbook of Procedure, volume 1 as opposite. The said importer did not fulfill the export obligation within the stipulated period of 18 months or extended period. This I have done, your lordship. Yesterday I had handed over a list of date, your lordship. If your lordship has that, your lordship, the fourth entry.
Yes.
29th and 30th December 2019, I have exported the goods. So I have fulfilled the obligation. And your lordship, the next point is the importer failed to comply with the provision of para 4.44 of the handbook. Within 2 months from the date of expiry of the period of obligation, authorization holders shall submit requisite evidence of discharge of export obligation in accordance with para 4.6. This also, your lordship, I have done. Your lordship, the fifth entry. Your lordship,
but
20.
These are on merit.
Your lordship,
you say that this is without jurisdiction.
Your lordship, yes, your lordship. In this case, my case, in this matter, the case is that the petitioner had been issued a authorization, advance authorization license, which is at page 40, your lordship.
Page 40.
Page
Yes,
40.
you have shown this.
Yes. Your Lordship, in this authorization letter, I get to import duty free for the purpose of manufacture. Your Lordship, your fourth and fifth entry from the bottom, Your Lordship will find validity for authorization script for import and export. Both is given. So, Your Lordship, within this time, I have to make the import and export also, Your Lordship.
2 months from the date of expiry of the export obligation.
Yes, Your Lordship. So I have done that, Your Lordship. At page 84, the document is there that, Your Lordship, I imported duty free under this authorization within time. I exported, I blended in the goods in the, it bears the custom seal. Then I exported it, shipping bills are there. Then, Your Lordship, within 2 months, as per the requirement, I informed the custom that the DGFT, that I have discharged the obligation. Kindly issue an export discharge certificate, Your Lordship. Your Lordship had asked me yesterday, what is this EODC, Export Obligation Discharge Certificate? I had asked at page 84, Your Lordship. And Your Lordship, then I was pointed out by the DGFT that this license details is not mentioned in the shipping bill. At page 93, Your Lordship, that letter from DGFT. 84 is my letter, Your Lordship, writing to DGFT saying that I have fulfilled all the obligation. Kindly issue me a discharge certificate, Your Lordship.
Where have you written that?
Your Lordship, page 84.
84. 84, yes.
We enclose here with the following document for issuance of export obligation discharge
Issuance of
certificate.
export obligation discharge. Yes.
Again, fulfillment of export obligation.
And this has not been disclosed.
Now, Your Lordship, this, in reply to this, they pointed out that there is some defect, procedural defect, Your Lordship, at page 93. That the details in the shipping bill, Your Lordship, the license details are missing.
This you reply.
When I received this letter from DGFT, Your Lordship, I immediately write to the customs proper officer, Your Lordship, under section 149, there is a provision that for amendment, because Your Lordship, procedural defects may occur. This is a beneficial provision for the exporters and importers. So, Your Lordship, at page 113, 109, Your Lordship, on the same date, Your Lordship, I write to the customs proper officer under section 149, which is Deputy or Assistant Commissioner of Customs. Your Lordship, I handed over a notification showing that this is the proper officer for the purpose of amendment. Now, Your Lordship, may I place section 149, which is for amendment, Your Lordship.
Forty-nine.
149, section 149, Your Lordship, amendment of documents. Save as otherwise provided in section 30 and 41, the proper officer may, in his discretion, authorize any document after it has been presented in the customs house to be amended in such form and manner, which within such time, subject to such restriction and condition as may be prescribed, provided that no amendment of the bill of entry or shipping bill or bill of export shall be so authorized to be amended after the imported goods have been cleared for home consumption or deposited in a warehouse, or the exported goods have been exported, except on the basis of documentary evidence which was in existence at the time the goods were cleared, deposited, or exported as the case may be. So, Your Lordship, at the time of export, the contemporaneous document may be considered and my application for amendment may be decided. But Your Lordship, they kept it pending for long 5 years. In 2023, Your Lordship, I had again written a letter, Your Lordship. That letter is at page 109, Your Lordship. Your Lordship, I will, at page 1010, Your Lordship. 110, Your Lordship. In this letter, Your Lordship will find in the second paragraph, I have referred to the earlier letter, Your Lordship. When the mistake was detected, we submitted letter reference number so-and-so dated.
This 23/11/2010 is the
Your Lordship.
That
This
is
is the
109.
second letter. This letter, Your Lordship.
I was asking whether this 23/11/2010 is this case 109, no?
Yes, Your Lordship.
Yes, reference ABEX, yes.
And in 2023, I again relied on this letter, Your Lordship.
Yes.
To which they, Your Lordship, replied in, to which they were silent. They never disputed this 2020 letter. In 2024, Your Lordship, at page 149, Your Lordship, second last page in the first volume.
Yes.
Your Lordship,
They say
here,
they point out discrepancy in one of your bills.
Your Lordship, this is by the superintendent. He is also not the proper officer to decide on my amendment. He said that he is putting forward one to the higher authority for consideration. But in reply to this, Your Lordship, next letter I have said that both should be put up to the higher authority. Your Lordship, this was kept pending. If Your Lordship, I have exported the goods, Your Lordship. I have, Your Lordship, if Your Lordship sees the
His proposal is based only on this.
only on this.
There is no other ground.
No, Your Lordship. They are saying that, Your Lordship, this advance authorization was issued to me. I have discharged the obligation under the advance authorization by making import within time, by blending it and exporting within time, by getting foreign remittance within time. And within 2 months, as per the requirement, I write to the Director General of Foreign Trade, who is the issuing authority, saying that I fulfilled, kindly issue a discharge certificate. At that juncture, Your Lordship, I'm informed that there is a defect, that the license details are not there. I write to the customs proper officer under section 149 to allow amendment. I write it within 1 year, Your Lordship. That is kept pending for 5 years. In 2023, I have again written. In 24, they have said that they are putting it up to the higher authority. And Your Lordship, in 25, they issue this pre-show cause, which is honest, because section 124 does not contemplate. And in 2025, they have issued this. And Your Lordship, they have thereafter proceeded to issue show cause, suggesting that I have not complied with my obligation under the license which was issued to me. And Your Lordship, I had placed 2 paragraphs from page 189, where they are saying that you have not exported the goods and you have not submitted the documents within 2 months. These both things I have done, Your Lordship. The only thing is correction. And Your Lordship, I had cited 2 judgments also yesterday. That Your Lordship, my first is a very short judgment, Your Lordship. Just Your Lordship, 2022 380 ELT 241. 1 page judgment, Your Lordship.
Yes.
Your Lordship, here the Supreme Court has, the Honorable Supreme Court has observed that the intention has to be gathered from the inception. What was my intention? If I have expressed my intention to avail benefit of the scheme from inception or not. So Your Lordship, the document at page 84, within 2 months, I informed them that I have complied, kindly issue me a discharge certificate. Your Lordship, I
Which is the authority which issues the show cause?
Your Lordship, the assistant, the additional commissioner, Your Lordship,
And
under
who is
120.
the authority who is going to decide on the amendment?
Your Lordship, if assistant or deputy commissioner, Your Lordship, that circular I had handed over. I have 1 more copy, Your
No,
Lordship.
no, I have it.
Yes, notification, Your Lordship. Point number 3, Your Lordship, deputy or assistant commissioner.
And under 124, which is the authority?
Your Lordship, it is mentioned in section 124 itself, 124 itself, Your Lordship. Not below the rank, Your Lordship, 120, section 124A. Your Lordship, this notice is to be given by an officer of custom, not below the rank of an assistant commissioner of customs.
So the same authority who is issuing this notice to show cause can also consider that?
No, Your Lordship, that is, Your
Why
Lordship, Your Lordship, that is additional commissioner, sorry, Your Lordship, that is deputy commissioner or assistant commissioner.
Yes.
Your Lordship, this is also
has to be, if it is not below the rank of assistant commissioner,
Your Lordship,
then it can be assistant
Your Lordship, that is
commissioner and above.
export department, Your Lordship. 'Cause, 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 ' Your Lordship, these are two separate proceedings, Your Lordship. One is under 149, which is a beneficial provision. And Your Lordship, the regulation requires them to decide it within 1 month, Your Lordship.
No,
Your
if
Lordship,
it is the same officer, then your case will be better
Your Lordship,
because then the exercise of jurisdiction is more painful. Because if he is the officer who is to take a decision and if he falls in taking decision and then to issue notice, then in that
I'll
case,
just check, Your Lordship, just 1 second, Your Lordship. Who has issued the show cause? I'll just check. Your Lordship, Additional Commissioner Appraising Group 1, Court, has issued page 193. And Your Lordship, the proper officer, Your Lordship, my application at page 109. Is Deputy or Assistant Commissioner of Custom Export Department, Your Lordship. Your Lordship, whoever may decide, Your Lordship, my objection is to issuance of show cause without deciding the amendment. Because, Your Lordship, if the amendment is allowed, then there is no requirement for any show cause. Your Lordship, the show cause may be kept in abeyance and Your Lordship, they may decide on.
But the show cause is not against the penalties. What they say is that there is an amendment application which is pending. In spite of that, the show cause has been. Now, the pre-show cause notice was issued today. They could have vented this point to the show cause issuing authority. And even if the pre-show cause notice, they can disregard because the pre-show cause notice even if they disregard and if they come straight away to the show cause notice itself, in the show cause notice itself, they can highlight this issue or take it as one of their plea or defense. That can be adjudicated while the show cause is adjudicated. And number two, if you are to see section 5 subsection 2, it says that whatever a subordinate can decide, that can be decided by the superior officer.
that has always been there. Unless the higher authority is the appellate
Yes,
authority of
yes.
the subordinate, then
So therefore, my lord,
using a
therefore these two issues can be conveniently decided and adjudicated by the show cause issuing authority who and the authority who is going to hear the said show cause. Our allegation is that she has availed of a scheme of export authorization scheme whereby he has the petitioner has imported tea without discharging the duty. And there
No,
was a
but if the submission of the petitioner is true, that if the amendment had been allowed, then in that case there could have been no occasion to issue the show cause. Then if that is the only ground on which show cause has been issued.
To that respect, I only submit that even if they take that defense, that will say before the adjudicating authority is very much very in power to consider that and pass necessary order regarding that ground also. Even when the Honorable Supreme Court has said the law to face the law to the extent that even a point of jurisdiction of the adjudicating authority or the supervising authority can be taken before that authority itself, and it has to be decided by that authority. And over here in this case, they have not taken the issue that I lack jurisdiction to issue the show cause. They only say that there is a procedural lapse. And the procedural lapse is that there has to be an order on the point of amendment, which has not been done. They say that if the amendment is allowed, in that case, they don't fall foul of the show cause notice. So that's one of their defense. So they can raise this defense.
What is the situation in reality? If the amendment is allowed, the show cause will go or will still remain.
That is for the adjudicating authority to decide, my lord.
No, on the facts of the show cause notice, there are charges leveled.
Or in the show cause notice, what we have said is that he has imported without payment of duty by taking advantage of a scheme.
If the amendment is allowed, then in that case, do those
that is
charges remain?
My lord, I again say, my lord, that it is subject matter of adjudication that has to be adjudicated upon taking evidence and upon appraisal of documents.
We are not going into the merits of the charges at all. We are on this small point that if suppose everything had been in order, this duty thing, this amendment thing had been allowed, Then in that case, is this the only allegation on which the show cause has been issued, or there are different allegations also clubbed together?
If your lordship kindly consider show cause 1.
Yes, that is what I wanted to.
At page 178.
Yes.
It has been summarized as to why the show cause has been issued.
Yes.
The show cause has been issued, as I have understood, is that they have imported black tea to India. That was done under advanced authorization scheme. And taking benefit of the advanced authorization scheme, they have not paid any duty while they are importing. And they had a concomitant obligation to export the same. Now, these are all matters of evidence and matters of appreciation of record, whether they have done this or not. Therefore, my lord, in their reply, if they have exported, they can come up with supporting documents and place it before the adjudicating authority for decision on merit.
It's basically on that only. Non-fulfillment of export obligation. And the exemption that is sought is also of that only.
So if they say that they have complied with it, let them take the record in support of their contention.
Yes, sir, what is the problem in you going to the show cause, answering the show cause notice, taking whatever you have said here?
Your Lordship, I'll answer to that. Your Lordship, there's a regulation where the respondents are under an obligation to decide my request for amendment within 1 month, Your Lordship. They have not done. Your Lordship, what is the object of section 149? It is a beneficial legislation that if the exporter makes any mistake on the basis of contemporaneous document, it should be corrected so that he can get the requisite benefits, Your Lordship, which is meant for exporters. That is section 149. And Your Lordship, what is the object of a proceeding under section 124? It is to punish me for non-fulfillment. So Your Lordship, today whether I have fulfilled or not is premature because of their fault, Your Lordship, in not deciding the amendment. So Your Lordship, why should I submit to a jurisdiction under
No,
section?
answering to show cause will not amount to submission to
Your Lordship, I will
jurisdiction.
participate in this proceeding.
Doesn't matter.
Why should
If you have participated in a proceeding before an officer who does not have jurisdiction, your participation will not confer jurisdiction on the officer.
Jurisdiction under section 124 to a so-called good bad, he has a jurisdiction.
Yes.
And Your Lordship, what is the case that I have not?
That is why
my
he has jurisdiction to issue show cause, and the show cause cannot be faulted on the grounds of inherent lack of jurisdiction. Then you answer the show cause saying that this show cause is premature because of these reasons. You have exercised the jurisdiction wrongly. Now, even after that, if you proceed, you have your remedy. But
Your Lordship, in this proceeding, all I am asking is that Your Lordship, the show cause may be kept in abeyance. My amendment may be decided. And then Your Lordship, I have a defense to offer. Still, my amendment is decided, Your Lordship. I have no defense to offer, Your Lordship.
that is also right, Mr. Dev. The so called, if the amendment is decided, maybe there is nothing.
In that case, also kindly direct the authority concerned to decide both the amendment as well as the show cause simultaneously.
Your Lordship,
No,
it cannot.
amendment will be decided first. So cause I am not quashing. So cause will remain in abeyance. The answer of the amendment will be given to her, and then we will proceed with the show cause.
To that effect, my lord, I will submit and relying upon only one decision of the Honorable Supreme Court. While the Honorable Supreme Court has said this, my lord. This is the case of Gulam Rao Singh. And in para 5, Honorable Supreme Court clearly says that whether the Stoker's notice was founded on the legal premises is a jurisdictional issue, which can even be asked by the recipient of the notice. And such issues also can be adjudicated by the authority issuing the very notice initially before the agreed approach. So therefore, if the petitioner is evidenced by the procedure adopted by the respondent or the so-called authority, the petitioner can take up this point before the in the proper notice procedure itself, so that it can be. Okay, yes. My lord, kindly. So therefore, my lord, it can all be decided in the scope of notice itself, proceeding itself. Doing the honor supreme court has gone to the extent of allowing the party to raise the point of jurisdiction also.
So this is where there are factual issues. But here where the show cause is premised on some fact, decision of which was also to be taken by you. You delay the decision and then issue show cause.
But that can be additionally decided.
But why should you not be accountable for you not taking steps in time? If something could have been done in 1 month, the person would not have been harassed and would not have had to face the ignominy of facing a show cause. Answering a show cause issuance of show cause and answering that is not an easy thing. It's a serious thing. Somebody being issued a show cause is not an easy thing. Somebody has been issued a show cause with that. There are decisions even to that effect that show cause does not give rise to a cause of action. But when an issue of this nature is raised, where you yourself are to take a decision, and your delay in taking a decision is having an effect of issuance of a show cause to somebody else, should that also be ignored by the court?
That is the reason why the pre-show cause notice was issued to them, to which they have declined. If they had answered to the straight pre-show cause notice, the matter could have been sorted out. They were given a chance. They say that the pre-show cause notice is without jurisdiction. So they could have agitated all these points even before the show cause was issued, and these things could have been sorted out.
That's right. There was some kind of obstinacy in the part of the petitioner.
But why
Every time you cite rules,
No, you're not.
then
I think
then
the
rules
logic,
are
there
against
was
you
logic
also at
not
times.
replying. There was a logic because your logic, this export was made in December 2019. And your logic, maximum time, even in case of suppression, to issue a show cause under section 28, the limitation is 5 years, which had expired in December 2024. So your logic, the department could not have issued a pre-show cause under or a show cause under 28. And your logic on
Very well, but
under one
if you answer a show cause, that will not bring it within the fold of limitation if it has been issued beyond limitation, nor will it clothe the authority with jurisdiction if the authority is not having jurisdiction. So your answering is show cause is not going to go against you. Non-answering is definitely going to go against you. It will weigh with the court in a different way. As Mr. Day specified.
That pre-show cause, your logic, I have shown that it is honest. And your logic, the logic was
not
that
honest.
because the regulation
There is a compulsion under the rules to issue a pre-show cause notice. In that case,
section 20
without compulsion, there is no prohibition. If they ask you to answer something, for example, when I write a representation to an authority writes, a person makes a representation before the authority concerned. We don't have to have a provision separately providing for such making of representation. And the authority cannot say, I will not consider the representation because there is no section which binds me and obliges me to consider the representation. As we are called for, you could have done away with all this litigation.
in any event, your lordship, after the pre-show cause, we have not taken any decision on amendment. It is still pending.
That I will decide them to take. That I will decide them to take.
Show cause may be kept in abeyance because your lordship, show cause is allegations that I have not fulfilled. And your lordship, I have already applied for amendment. If the amendment is decided,
I will grant you time to respond to this show cause. I will keep this point also open that you can challenge the basis of the show cause on the ground that the amendment has been kept pending. Alongside, I will also pass a direction on the authorities to expedite this and decide the amendment within a specific time frame.
and your lordship, the time to reply maybe after the amendment is decided. Your lordship.
No, I will do this. I will grant the time to decide the amendment maybe in 2 weeks. And I will grant a little longer time to you to file a reply to this.
And your lordship, for amendment,
I'll be obviating both the things.
Your Lordship, for amendment, I may be given a hearing also, so that I can produce all the documents, if anything.
Very well. Since it was to be done in 1 month and almost all.
Time limit is given to a authority. It's discretionary. It's not mandatory.
But it cannot be 4 years then.
I'm not.
It has been now 5 years.
I'm not justifying that.
So Mr. Deb, that 1 month is now 5 years. It's more than several more months. So now you do in 2 weeks. After hearing. You do in 2 weeks and I'll grant. What was the time originally granted by the show cause?
Lordship, 30 days.
30
Added in
I
accordance.
have said you have given the clarifications. I have not gone into the merits. I have said whatever was asked for, you have given.
Your Lordship.
Now they will take a decision. I have not. It is clarified that this court has not gone into the merits of the matter. Merits of P. Yes.
The instruction that we have read that last week was fixed, we can do that. And that day will be kept, that matter
Couldn't be taken up. It's pending. Appeal is pending.
and
Well, it's 16th of December. Next month.
next
Yes.
and
लिखे नहीं पहले दूसरे के लिखे नहीं
22nd, 22nd to 20.
as jointly prayed for
You're obliged.
चलो next
Matter of reason, I got 23.
yes yeah other side is there yes.
Yeah, Julia is there.
India has rushed into the court to cover 28, my lord. So
tomorrow
Can I take up at 2 p.m., my lord?
no, I'll not be able to fix because there are others also. I will not give a time. If both of you are here, you mention, I'll take it.
Okay.
Chalo, next. No, you please follow the list because tomorrow I have a division.
Yes, another
I
page
don't
is
know how
there.
will I arrange.
Yes.
Right now, I'm unable to tell you. You keep a watch on the list. There will be an indication in the list. Then I'll be taking up a relation.
Thank you.
grateful, man.
Yes.
For the petition, your lordship, that group six matters together, your lordship. Maybe come any other day, your lordship. It will
Yes, because it will take time.
It will take some time, your lordship.
When should I take? आपके पास कितने? लिखिए दिन. Third learned advocates appearing for the respective parties as jointly prayed for list this matter once again on January 7, 2020. 7 January 2026. 5-11.
All the numbers and all numbers 5, 6, 7, 10,
5, 6, 7,
10, 11, 27.
10, 11,
And
27.
27. And 27.
तो एक ही नाम আছে দেখেন মান্ডিকা অনেকগুলো আছে 5 6 7 10 11 27 একই নাম আছে একই নাম সবকটা অর্ডার সবকটা সেপারেট করে অর্ডার ये
Eight, 12, and 21. But same petitioner, different years are involved. And same issue, same facts.
What is the issue? What
Lord, this is otherwise a covered issue by the division bench in the case of Girdhari Gopal Dalmia. Girdhar Gopal Dalmia.
faceless?
No, no, not faceless.
Then?
This is, my lord, relating to. This is, my lord, there was a search and seizure at the money broker's premises. There, my lord, the records were found that certain persons were advancing unaccounted loan. And the allegation is that I am the beneficiary of the loan. I have taken loan from different persons in cash. So, my lord, but here what is happening, my lord, AO is groping in darkness. The information that he receives, my lord, in the information, my lord, what the AO is trying to do, even in, there is no material on record that I have taken loan. Even the allegation is that the company in which I am a director, they have taken loan, and there are some other entities, parties with which I have no connection. But for a very strange reason, I have been issued notice. And the word used is potential, probably, all these words have been used in the information, which means that the department is doubtful about the entire affair. And this is reopening of case. So Girdhar Gopal Dalmia, the division bench has dealt with the similar issue and came to a conclusion that when potential, probable, these words are used, that these words are fatal to the reopening proceedings. And my case stands on a much better footing in the sense that I can demonstrate a table has been prepared in the information on the basis, allegedly on the basis of the documents found at the searched premises. And from the table itself, I can demonstrate it is not the case of the department that I have taken cash loan. And it becomes amply clear from the so-called notice where he is invoking section 179. He is talking about section 179, which is invoked when when the department fails to collect tax from the company. Now he is jumping the gun, not following before the assessment is done, before the addition is made, he is invoking section 179 and trying to impose a liability upon me. So this was not fact in the Girdhar Gopal Dalmia. There the allegation was that the SSC petitioner concerned has taken loan.
Show me, please show me the order.
Firstly, my lord, may I refer to notice at page 23.
Page 23.
My lord.
Yes, this is 148 1A notice.
148 A. Now it was 140. Earlier it was
A was
A, small a. Now it has an old wine in a new bottle has come. Every year they are making a new law, changing the structure of the. Now, my lord, kindly come to the annexure. Departmental Insight portal, which reads as under Uma Sankar Kasera, cash loan taken 55 crore, beneficiary of finance broker. Search and seizure along with survey operations at various spots of finance brokers were conducted. During these operations, huge number of incriminating documents in the form of RUCA and other documents were seized. On analysis of the seized documents, it is found that the SSC Mayank Agarwal, Managing Director of the Maya Fashions Private Limited, Telja High Rise Private Limited, has taken cash loan amounting to so much through finance brokers. It is to be noted that Section 179 of the Income Tax Act specifies certain liability of directors of private company. Then he has quoted, my lord. From there, it is
Where is the
apparent.
148A3 order? Page
160.
160.
160. It is second one. Finding is at page 175.
The detailed order.
But my lord, the objection that I have raised and what they have provided in the information, now it is a tangent with that. Just only legal points, case laws.
What was your specific objection? Where is that?
My reply, my lord, objection is at page 141. My lord. At page 145. It is stated before your good self that along with the aforesaid so-called notice, your good self has provided us copies of two statements under section 132(4) persons named Uma Sankar Kasera and Praveen Kumar Kasera. In this regard, it is submitted that before your honor that we have gone through the entire statements of the aforesaid persons. In the entire statement of either of the persons, there is no reference of the name
You
of
asked
the
for an opportunity to cross-examine.
No, that is also immaterial, madam. Because when in the first place, there is no reference to my name or to the company name of the company in which I am a director. Cross-examination is totally immaterial. I am not implicated. Now, because either he does
That
not.
is the only basis. Only the statement is the basis.
Statement and the information. Kindly come to the information, my lord, that they have shared with us. Page number 85.
Yes.
My lord, modus operandi. There are basically three types of persons involved in the unaccounted cash loan transaction: lender, borrower, and finance brokers. Now, their case is that I am the borrower. Some charts and different these things are given. What is important is the table, just of page 92, my lord. What they are saying. Group name at para 19. Mayank Agarwal, oblique Murari Lal Agarwal. He is not even a close relative, some distant relative.
Yes,
Maya Fashions, Telja Fashions, potential lender or borrower status borrower. Probable unique names coming under different format of lender names in the annexure listed below. These are the entities. Then, my lord, in the table, my lord, let us come to page 93. My lord, borrower name is given. Entire table, I have scanned the entire table. Nowhere my name is there. Timaya Fashion is a private limited company in which other directors are also there. So that basic knowledge of income tax, if we are aware of the basic knowledge of income tax, every assessee is that if a company has taken loan, there is a company has taken loan, then you issue notice against the company. Why proceedings against individual? In the outset, he is saying 179 I am invoking. That can be invoked only if the company fails to pay the tax. Here, not even the proceedings have been initiated against the company, let alone the payment of tax. And thereafter, borrower, next column says, if we see the preceding page, borrower grouped by. That column is borrower grouped by. And all these entities are grouped under me. So either the department has a great animosity towards me, that any document they are founding related to the company or a distant relative, I will be hauled over the coals. I will have to answer for that. First, in the first place, you give the material, or even there should be some allegation that I have taken loan. Their own case is that somebody else, some entity where I am a director, they have taken loan. How can the notice be issued against me?
How have they connected you to the company? Where is that government?
In their
yes,
order.
There must be some allegation against you.
In the order, they are not. They are bypassing all the rebuttal that I have, the issues that I have raised. Only case laws, full of case laws, which are irrelevant to my case. And
there is no allegation leveled against you in the
so cause itself is saying that because your company has taken, I invoke section 179.
Apart from the director, what kind of connection you have with the company, that has not been mentioned anywhere?
Nothing that I am the Benam. Either they should say that I am the Benamdar. In the guise of the company, I have taken loan. Actually, the loan has come to me. That sort of allegation should be there. That is also not there. And on a much simpler...
Yes, Mr. Dudhoria, what is your instruction on this?
But, my instruction is that since he is one of the directors of the company, if the Lordship will kindly see the show cause notice, I'll place first 148(1), then thereafter the modus operandi, how this this Casera group, how this the accommodation entries where he was also one of the directors. Lordship will kindly first come to 148 A1, that is page number 23, page number 24. Your Lordship will find there was certain figure on the basis of analysis of the document. It was found that the SSC Mayank Agarwal, managing director of Timaya Fashion Fabric Limited, and such has taken cash loan of rupees 55 lakh in his book. And it is to be noted that therefore, 178% has been initiated. Now, but Lordship will kindly say the modus operandi. How this Casera group, this on the basis of a certain seizure of a Casera group, it was found that the modus operandi in the modus operandi, how this entire thing was done, it is specifically stated, and thereafter placing the order. If your Lordship will see the modus operandi, your Lordship will find the page number 85 is the modus operandi. May I just indicate one or two? There are basically three types of person involved in the unaccounted cash loans transaction: lender, borrower, financer. Financer, broker act as a link between the lender and borrower. The cash loan transactions are arranged through broker in lieu of the certain percentage of brokerage. The brokerage earned a check brokerage earned in check is only enter into regular books of accounts, whereas the brokerage received in cash is not brought on regular books of accounts. Majority of the transactions are in the cash.
This is all literature. Where is the allegation against him? How he is connected to this?
But allegations is not in the notice. He's one of the directors. He has taken loans. This is apart from
first time income tax act, we have to relearn that any company or any relative takes loan, so I should be held responsible for that. This is for the first time in my 30 years career.
Page number 92, the group name is Mayank Agarwal, Murari Agarwal, Himaya Sadhu, potential lender, borrower, taken page number 92, so far as the order is concerned, if you will kindly please the order which was passed under section 148.8, that's page number 160, from the order also. These submissions are categorically is considered and
in this case, even penalty order has been passed. 271 capital D, 100% of the penalty has been imposed upon me.
And also several.
A dead horse cannot be whipped again and again. The only, my lord, another important legal point involved is that how can there be escapement of income? Their case is that the loan has been taken out of books. Loan does not partake the character of income. There the provision, specific provision is there in the Income Tax Act, section 271 capital D. If I take loan, cash loan, you will penalize me for that 100% of the penalty. But where come you can initiate proceedings for reopening, even giving a long rope to the revenue. There is no material, no in the statement, nowhere my name has been taken. In the table, their case is that the loans have been taken by other entities. Now, even assuming my name is there, still there is no element of escapement of income. If something is recorded in the books, then by deeming fiction, section 68, they can apply. They can say this is your money which has come back. But this is not their case. It is their case that you have taken loan, cash loan. The person who has given the loan, his income has escaped assessment because the loan is in cash and he has to explain the source. But when I have taken cash loan, loan is not income. But even deeming fiction will not apply because they say that it is not your money. Deeming fiction 68 will apply only when they say it is your money which has come into the books. These are all out of books transactions. So they can impose penalty. That penalty also they have imposed. Now they want to reopen the case. So dead horse cannot be flogged again and again. And the case is
page number 185.
100% covered by the division bench of this honorable court, where on much weaker.
Yes, Mr. Page 185, 185, page 185 of the order, internal page 26. The notice is validly issued based on the tangible, credible, and specific information. The proceedings under section 148 have been initiated based on the information gathered in the circular operation conducted in the entry operator broker of Uma Shankar Kasera, Praveen Kasera, and also the Kasera Group. The information consists of information suggested income taxable. The SSC is not a mere director in the name of. SSC is not a mere director, but he is a managing director and the principal decision making of in both the Himaya and Shailaja Group. The companies are closely held and the financial dealings are obsessive and controlled solely by the SSC and the immediate family members. Therefore, it is not only legally permissible but also factually justified to examine the income escaping assessment in the hands of the SSC, who is the beneficial owner of the control of such transactions. Therefore, this judgment was cited, and thereafter, why section 179 cited a legal proposition. The SSC is assuming that the department is invoking section 179 of that. At this stage, no claim has been created against the SSC. Only the 179 is not being invoked. And the recovery proceedings, however, the reference of section 149 is to show that no notice is established. So, but it is he is the only person who is looking at the managing director.
Managing director, how can they invoke at this stage?
They have not invoked.
They have not invoked, they have taken reference to that.
Yes, they cannot jump the gun.
That is not what I'm.
They cannot jump the gun. How can, admittedly, the loan has been, their case is that loan has been taken by the company.
They are trying to show how a director can be held liable. It is by way of an argument. It is not invocation of the provision.
For 147, these pleas cannot be taken up. And on a much weaker, my lord, my case is much stronger. On a much weaker case, division bench has quashed the proceedings. Because on suspicion, probability, all these you cannot invoke section 147, my lord. And it talks about, if we read even section 147 and 148, my lord, it talks about escapement of my income, not anybody else's income. Lord, kindly see.
Very well.
Mr.
Agarwal, jurisdiction fees. I don't have jurisdiction anymore.
We'll come back on Monday, my lord.
Same allegation.
Page 12 and 21. 12 and 21 একসঙ্গে করে দেবেন ওই অর্ডার কিছু করছি না ট্যাগ উইথ করলে আবার একই অর্ডার দিতে হবে এটা ভালো ফ্যাক্ট তো আলাদা আলাদা উইথ করবেন না উইথ করলে তো ফ্যাক্ট আলাদা আলাদা অর্ডার দিতে হবে ঝামেলা হবে এবার ওই একটা অর্ডারে পর পর করবেন পর পর করবেন It will be there in the list. It will be there in the list. If you are not there on Monday, I mean on the next day, I'll keep it with you. I remember it. So they will be there definitely.
Yes, sir.
He'll remind me.
They should.
Thank you.